Yeah.
Can I get a signature?
Yeah,
on
sure.
this?
And I see you sent me something else, and so I'll be signing that in just a moment.
Okay.
Okay.
Why didn't I think this was that heavy?
Why did I not?
Tell your mom hi, give that baby,
Okay,
give that beautiful baby a huggy kiss.
okay, and guess what mom said?
What?
She said she will not be wanting because the baby's sick. And she's like, she wants to see Coco Melon. So,
Well, tell mom to use her phone and put it on YouTube.
okay,
To watch from YouTube on her phone.
yeah,
Yeah, I know babies take control over.
oh, they do.
Baby.
Thank you.
All right, who are the parties on Reynaldo Rodriguez?
I'm here, guys.
All right, is your client in custody?
He's in custody, yes.
Oh, just a moment, they'll be bringing him out in a moment. You don't mind? What?
Is this how y'all?
Yeah, as I said, he used to be at a place that I don't know.
That's no, like, it would make me interested. That's very organized.
Marcus of Britain, if you all could review this and see if you have any objections to it.
Sure, sign is not.
Judge, may I approach?
Oh, yes,
I am here on David Rodriguez.
yes.
I'm gonna, I guess it's a trial setting. I don't think it's a discovery.
All right, just give me a moment and let me look at it. Let me just sign this documents and I'll do that.
Okay, I don't have an offer, so that's what we're working on.
Okay, all right, thank you. All right, are you here? Is Ronaldo out?
He's not out yet.
Okay, just give us a moment. We'll make that happen. Oh, what page is it? Mhm. Okay, all right, thank you. Okay. All right, thank you. Okay, everyone, we do have jurors in the hallway. So if your case is going to be working on it, please going to be entered then you need to get that to the court as quickly as possible. Can I see the files on Adam Carroll? I'm assuming he's still a fugitive.
Yeah, he's still.
Okay.
I think it was there was also a violation report. That's Joshua. You wanted Adam?
Yes.
Yeah, me too.
You're like, I forgot to ask.
I was gonna say, I was about to like. No, because I think. Yeah. No, I just said she can't, she doesn't. During the summer, yeah, and then like, she helped out.
Norma, on Adam Carroll, is his attorney Jay Norton?
Yes.
All right, so he's not a fugitive on the cases that have been indicted. So we're gonna have to recall it if he's not, and make sure Jay Norton is here so we can. Yes, then just have this recall for tomorrow, and we'll take care of that. As soon as your guy comes, we'll take that up. And Caroline, you can
Did you want it to know just or is it on the meters?
Oh, just say grant. So that they'll be there. They said that the state is already in compliance with everything. So. And this is asking for them.
Oh, I saw.
So that's what they said.
Oh, that's scratching on them. They're like, it's all- what's called- Okay, I wasn't available this morning. I just-
All right, the parties here are Matthew Burke. Yes, so what are we doing in this case?
I don't know, Judge, I filed a continuance for 2 weeks, but if the court's not inclined to give me that, then,
I don't have your motion.
I have a copy of it, but I did verify with the district clerk's office that it was. Make sure I'm handing the right one, 'cause I thought I needed to, but this was not the case. This one, this one. I think those go together.
No problem, thank you. Brenda, are you ready? Yes. Parties calling 2021 CR 3503, State of Texas versus Matthew Burke. Could I have parties announced for the record for the state,
Michael Villarreal for the state.
for the defense?
Carolyn Whitman, for the defendant.
And are you Matthew Burke?
Yes, ma'am.
All right, this is scheduled for jury trial. State defense has filed a motion for continuance today. Have you had a chance to review the defense's motion for continuance?
We've conferred about the motion.
Do you have any objections to the continuance?
I do not know.
Ms. Ferguson, when do you want to bring this back?
On the ninth.
That's fine.
It's fine.
All right,
On the 18th, it will be the 18th.
the 18th.
Yeah. Sorry, that will be Monday.
All right, and that will be an impact.
Yes, ma'am.
All right, then defense's motion for continuance is granted. Before parties leave, I'm going to want an acknowledgement of discovery done.
Yes, Judge, I'll do that right now.
Defense, have you received all discovery?
I think so.
Was an offer tender?
Was it what?
Offer tender.
Yes.
And Mr. Burke, are you rejecting that offer and requesting a jury trial?
Because I'm gonna be essentially nothing.
I need to tell them the new offer, Judge, because the other offer stayed in gold, so.
All right, do you want to tell them what the new offer is?
Well, I told you, Carol.
Thank you.
Just some.
All right, Norma, on her case, she's discussing with her client what the offer is. Yes. Yeah. All right, is Reynaldo Rodriguez out? Okay, we're gonna make that happen. Jesse Salinas? All All right, what is happening on this case?
Judge, my client, we respectfully decline the offer.
Okay. Respectfully.
Respectfully, Judge, operative word.
It didn't feel that way. Just kidding, Marco.
You're telling me.
All right, Mr. Salinas, are you requesting a jury trial?
Yes.
Okay. All right, Norma, on Jesse Salinas, if I can have a jury trial date. All right, so it's gonna be July 9th, well, 18th, correct? So you'll need to come back on July 18th, but you'll be in impact court. And before that date, I'm gonna need an acknowledge. Oh, I do have an acknowledgement of
That
discovery.
was signed off.
Yes, so do you have all the discovery?
Yes, Judge.
All right, so don't leave until you get a reset form from Ms. Ferguson, and that'll be for July 18th in impact. Donald Gilliland? Donald Gilliland.
He's in custody, Your Honor.
Oh, okay. All right, thanks. Ronaldo is in front of you. I remember which client was it for Charles Fox that had to get the stitches in the knee? All right. Could I see the file on the bone?
So Judge, I have communicated the offer to my client now that he wants, so.
All right, Mr. Burke. All right, Brenda, we're back on the record.
Okay.
So, Mr. Burke, the offer was tendered. Are you rejecting it and requesting a jury trial, or are you
Yes,
listing a jury trial?
Yes, ma'am.
All right, and Norma, the date for them is the 18th?
Yes.
All right, so you'll get a reset form from the coordinator. So you're gonna be back on July 18th, but you're gonna be meeting in impact court. Yes, and your attorney will let you know where that is.
Thank you. Okay.
Right now, it may be a late one. Today. Okay. With the jury selection. All right. Norma, what is happening with Teo, Michael Teo? That's Andrus Capian. Okay. All right. Okay. And I'm sorry, number, what date did you give Damone Wyatt? Okay. Let's wait and see then the update on the stitches. And then where's is Elijah, where is John Disru? And he's okay. Okay, thank you. Do you have your phone?
No, it's just car home. We had a plea arranged. My client is not returning for lunch. I have a 2 o'clock appointment. My dad's phone going to answering service or voicemail. Yeah, we have a plea agreement. Is there any way we can put him on your next plea docket and have the paperwork brought in? I'll get a hold of him.
He needs to come back tomorrow.
Try to get him back.
If he doesn't come back tomorrow, then a warrant will.
I
I
understand.
know, yeah,
I mean, I'm here.
because
They told me back at 1:30.
yeah, I'm looking at his Zoom privileges, or he's the one who had his Zoom privileges revoked. So I'll recall it for tomorrow, and if he doesn't show up, the warrant will be issued.
All right, thank you.
And Norma, I know that Wednesday is something. Mr. Acevedo, he'll need to be here exactly at 9 a.m.
Can we do the, if he's here, we can do the plea at 9 a.m. or?
Yes. And Norma, on that case, what will end up happening is when he comes in at 9, we'll do the doing a break if they're here exactly at 9. Okay. Okay, well, okay, well, we'll probably then have a jury at 9:30 and everybody needs to be here at 9. Okay. There you go. Okay, all right, and I'll will draw a low yellow line. Oh, Aguilar, when is that coming back? Yeah, we've already done. Oh, he quit? Yeah. All right, and then Caleb Coleman Lee.
Hopefully on the.
The 26th. Yeah.
Okay. Is that July 26th? And then Kevin Castillo. Okay. And Michael Campos. All right, we're gonna take care of that. And Petra Calderon, we did that, correct?
Yes.
And Aaron McDonald, and Adam Carroll, that's coming back tomorrow, right? And the attorney needs to be here for that. And then we have Teo. Okay. All right, are the parties here? Ronaldo Rodriguez. Court is calling 2020 CR 2618, State of Texas versus Ronaldo Rodriguez. Can I have parties announced for the record for the state,
Michael Villarreal, for the state.
for the defense?
Dave Sanchez, Your Honor.
Are you Mr. Rodriguez?
Yes, ma'am.
Showing you a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
I'm also showing you what's entitled First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Reynaldo Manuel Rodriguez who was placed on deferred adjudication in 2020 CR 2618 for the offense of possession with intent to deliver a controlled substance penalty group 1, 4 grams to 200 grams on January 25th, 2021 for a period of 5 years? Is that you?
Yes, yes, Your Honor.
State?
Violated condition number 1, on or about the 19th day of May 2022 in Beer County, Texas. The defendant, Reynaldo Manuel Rodriguez, committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
That's true.
And the state would waive it. If
Any objections to the state's waivers?
No, Your Honor.
Mr. Rodriguez, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, not grant you community supervision, and sentence you up to life in prison and up to $10,000 fine? Did you understand?
Yes, ma'am.
Sorry,
Yes, ma'am.
knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there an agreement?
Yes, Your Honor. A great recommendation is to grant the state's motion, enter an adjudication of guilt, assess punishment at 5 years confinement in the Texas Department of Criminal Justice. And in consideration of the plea, the state is going to take into consideration cause numbers, night mag 662373, county court cause number 685329, grand jury number 775256, and JN number 2074970.
Is that the agreement?
That's our stand. Yes.
Mr. Rodriguez, are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, the court will follow your agreement. The court is finding violation of condition number 2 true. I'm sorry, number 1 true. Court is finding you guilty, not granting you community supervision, sentence you to 5 years in the prison. Taking consideration night mag number 662373, county court cause number 685329, grand jury number 775256, J number 2074970. And the court will give you credit for any time served. Is there anything else from either side with regards to sentencing?
Nothing from the defense.
Mr. Rodriguez, I'm showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
I did, Your Honor.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, yes, Your
And
Honor.
because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand?
Yes.
All right, we can go off the record. Mr. Rodriguez, you're gonna have to do better. I saw that I had ordered parenting classes, which means to me that you have children. So when you go to prison, reflect on how to be a better person so that you can be your children's role model, okay?
I appreciate your time, Your Honor. Thank you. I will.
All right, good luck to you, okay?
Thank you.
Are the people here on Donald Gilliland? Donald Gilliland?
Yes, you got your-
All right, what is happening with this case?
Your Honor, concurred with the state, there was an agreed order for discovery that was signed back in May. I have given a copy of that to the state this morning. Part of the issue is that these are some electronic media devices that are in the possession of possibly various agencies.
Where's Donald Gilliland?
He's in custody, Your Honor, second row.
All right, Mr. Gilliland, come on down.
And so I've conferred with the state, and they are going to make an effort to locate where these specific evidence is and how it can be turned over to my expert. So the order from the court has already been signed. In addition, on the 2020 cases, we believe that there's some additional body cams and other media that hasn't been turned over. I've advised the state of that. I believe they have located those items in the co-defendant's case and have assured me that they'll be uploading that through the e-discovery system.
All right, and that's the 2020 cases?
Yes.
All right, and state this other discovery he's speaking of, when will that be uploaded or ready? Well, not uploaded, but ready for him to view?
The videos that we just found in the co-defendants.
Yes.
I'm gonna have our paralegal do it. She'll probably start it tomorrow, so we can have it uploaded this week.
All right, and then the 2022 cases, the issues with discovery that he has, when will?
We've got to contact the agencies, Judge. There's several involved and see who has what. So I don't know a time frame on that exactly.
All right, Ms. Ferguson, on Donald Gilliland, can I have a 45-day reset? Is anybody going to have an objection to 45 days?
No.
All right. And it'll be for discovery.
We can come back on August 18th.
All right, there's a problem with August 18th for me. I mean, well, another judge may be here. That's my younger brother's birthday. 25th? All right, August 25th. All right, and the items that need to be discovered on the 22 cases, which agency is that coming from? If you know, if you don't know, that's fine.
It's in the order. It's
Fair Oaks Ranch, I believe.
gonna be Fair Oaks Ranch, possibly Bear County Sheriff's Department.
All right, so I will see you all back then on August 25th. And if there's an issue with them handing that over, then everyone needs to subpoena whomever you need to subpoena, and we'll have them appear.
Here's the judge.
All right, Ms. Ferguson will give you a reset form.
Okay, may we be excused?
Yes.
Thank you.
Robert Andrade. Hello, what is going on with this case?
Judge, we've conferred and we're going to need to stay in the trial docket.
I'm sorry.
We're going to need to stay in the trial docket.
All right, just have a seat and we will see where we are. Ms. Ferguson on Andrade, where is that on the trial docket? All right, so just remain in court. You're on the trial docket.
To the end?
Yes, till the end. You can do it. All right, who's on Michael Teo?
I'm Your Honor.
Yes, what is happening with Michael Teo?
Mr. Taylor is in custody, and I think Mr. Rumor, who I was confirmed with, he just stepped out. The state, I believe, is going to be asking for a reset because this is the first setting since Mr. Taylor's been back in custody. He had been previously.
All right, Mr. Teo, come on up. All right, go ahead.
We currently represent him on the failure to stop and lender aid case. I believe that there are 3 other felonies that are still pending. And the state, before they make an offer, was going to review all of those. And I was going to coordinate with the defendant and his family to see about representation on the other 3 felony cases.
All right, so which cases are you representing him on?
The failure to stop or render it, and that's it.
So we have the burglary of the building. All right, and the failure to stop and render aid and felon in possession of a firearm
And I believe it.
and possession cases.
Yes,
All right, and so the failure to stop and render aid was re-indicted.
it was. To my knowledge, I haven't seen the new indictment yet. My defendant, my client has a copy. We just need to get our copy.
All right, so what discovery or what's outstanding?
I would imagine that as of right now, I think that the discovery is all the same from the re-indictment. I don't think anything has changed. So I believe we have the discovery on the failure to stop or render aid case. I believe, though, due to the existence of the outstanding felonies, there is a possibility for a global resolution. And we're going to be exploring that if the court will allow us.
All right, Ms. Ferguson, on Teo, I'm gonna want a 45-day reset. And that's for you all to work out whatever agreement you want to work out or not work out, Mr. Teo. All right, so 45-day reset and make it a jury trial plus plea deadline date. August 22nd.
It's fine with me, Your Honor.
All right, Mr. Teo, I'm seeing that these cases have been re-indicted, so the discovery, my understanding is still the same from your counsel. So August 22nd is going to be your plea deadline date and jury trial date. So if you decide not to accept the plea bargain agreement, which is fine with the court, you'll be having your jury trial that day. They will bring you dressed for trial if you're still in custody. You'll be brought over dressed in whatever clothing you have at the jail. If for any reason defense, your client wants to appear in something else, then of course you'll have to confer with your attorney on that. Defense, if there's an issue with the clothing exchange, let the court know, and I'll see what I can do to help expedite that.
I understand, Your Honor. It's I believe the possession case, the controlled substance cases, I don't believe are indicted as of yet. So that may or may not, I guess, come into play as far as the global resolution, but we absolutely understand that the 22nd is the deadline that we're working against.
All right, thank you. Ms. Ferguson will give you a reset form.
Thank you.
Thank you.
You're welcome. All right, who is here on Elijah Hamilton? All right, is there someone from the state available? Thank you. The court is calling 2021 CR 10655 and 2021 CR 10659, State of Texas versus Elijah Hamilton. Can I have parties announced for the record for the state?
For East Sparks?
For the defense?
John Disregard.
And are you Mr. Hamilton?
Yes, ma'am.
All right, defense, in each of these cause numbers, I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in each of these cause numbers, and did you review that discovery with your client?
Yes, I have one.
In each of the cause numbers, the court will find that the state is in compliance with discovery. Mr. Hamilton, in each of the cause numbers, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, in cause number 2021 CR 10655, are you proceeding on the indictment as presented?
Judge, I am unsure.
Okay,
Okay, so.
yes, it appears that you are.
Yes, Your Honor.
And then in cause number 2021 CR 10659. Let me see. It appears that you're proceeding on the indictment as presented. Is that correct?
Yes, Your Honor.
All right, then. Mr. Hamilton, in each of the cause numbers, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review those documents with your attorney? Did you understand them? Did you sign them in all the appropriate places?
Yes, ma'am.
In 2021 CR 10655, you're charged with the offense of possession of a controlled substance penalty for 1 less than 1 gram. The range of punishment for that offense is anywhere from 180 days, 2 years in the state jail facility, and up to a $10,000 fine. In 2021 CR 10659, you're charged with the offense of tampering with the evidence with intent to impair. That's normally a 3rd-degree felony. However, the state is proceeding on an enhancement allegation, so that makes it a 2nd-degree felony, and the range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand those ranges of punishment and what you're charged with in each of those cause numbers?
Yes, ma'am.
And each of the cause numbers, if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
And each of the cause numbers, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in, the right to remain silent?
Yes, ma'am.
And each of the cause numbers, did you understand by entering plea bargain agreements, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yes, ma'am.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
He is, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Hamilton, in each of the cause numbers, has anyone threatened you, forced you, or placed you in fear to get you to enter your plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
In each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Each of the cause numbers, I'm showing you the plea bargain agreement. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Cause number 2021 CR 10655, according to the plea bargain agreement, punishment is to be assessed at 6 months in the state jail facility. There's a $1,500 fine. This will run concurrent with 2021 CR 10659. In 2021 CR 10659, the plea bargain agreement is that you agree that you've been previously convicted of 1 or 2 more felonies for enhancements. Punishment is to be assessed at 2 years in the prison. There's a $1,500 fine. There are no applications. This will be concurrent with 2021 CR 10655. State will take in consideration the following cause numbers: 2021 CR 11651. County Court cause number 670-299, 681-631, 681-632. And also in cause number 2021 CR 10655, there is no application. Did you understand that to be the plea bargain agreement in each of these cause numbers?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
In each of the cause numbers, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal in each of the cause numbers? The only things that can be appealed are written pretrial motions that be filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then in cause number 2021 CR 10659, how do you plead? Guilty, not guilty, or no contest?
No contest.
And in cause number 2021 CR 10655, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendants, please.
Yes, Judge. State Office States Exhibit 1, all attachments in both cause numbers.
No objection, Your Honor.
Mr. Hamilton, in each of the cause numbers, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them and did you sign them in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes.
Did you understand today that the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Then in each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence in exhibits 1 and attachments. And in cause number 2021 CR 10659, how do you plead to the following enhancement allegation. It states, and it is further presented in and to said court that before the commission of the offense alleged above on the 6th day of June, AD 2019, and cause number 2016 CR 9897 in Bear County, Texas, the defendant was convicted of the felony of possession of a controlled substance, penalty group 1, 4 grams to 200 grams. How do you plead to that? True or not true?
True.
Sorry?
It's true.
All right, thank you. In just a moment. All right, each of the cause numbers, the court will find the evidence is sufficient to find you guilty. The court will find you guilty. In cause number 2021 CR 10659, the court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
In cause number 2021 CR 10659, as previously stated, the court is finding you guilty. The court will sentence you to 2 years in the prison, give you credit for any time served. There's a $1,500 fine. Time and money will run concurrent. This will run concurrent with 2021 CR 10655. Take in consideration 2021 CR 11651. County Court cause number 670299. 68131, 6813, I'm sorry, 681632. And in cause number 2021 CR 10655, as previously stated, the court is finding you guilty and sentence you to 6 months in the state jail facility. Give you credit for any time served. And this is run concurrent with 2021 CR 10659. There's a $1,500 fine, time, and money to run concurrent. Is there anything else from either side with regards to sentencing?
Nothing from the state.
No, Your Honor.
Each of the cause numbers, I'm showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document or those documents with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because you entered a plea bargain agreement in each of the cause numbers, because I followed your plea bargain agreement, Mr. Disrupt. Mr. Disrupt,
Yes, ma'am. Thank you. I appreciate
no
it.
problem. Because you entered into a plea bargain agreement which in each of the cause numbers, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? In each of the cause numbers, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, Mr. Hamilton, we can go off the record. Mr. Hamilton, how old are you?
26.
26? You have children?
Yes.
What are their ages?
I have a 5-year-old and a 8-month-old.
All right, so here's the thing. You're young, you can still get your life together and go on the right path. Children, I guarantee you, they would love to have their fathers in their life and be good role models. So you still have a chance to do that. So whatever has caused you to go on the path that you're on, you need to internalize how you got there, and then you need to try to do better, okay?
Yes, ma'am.
All right, good luck to you, Mr. Hamilton.
Thank you.
Can you see how many days?
$23.
Thank you, Judge.
Yeah.
All right, what are we doing with Robert Andrade?
That was the trial. Ruben Martinez.
Ah, yes, okay. Just one moment. Just have a seat. Is there anyone else ready? Yeah, just, don't file those away, but. And Norma, can you make sure that Miguel is here? All right.
He's here.
Oh, he is? Okay, I don't see him. He's in the gallery. Is that the first one that's up, Norma? Yeah. All right, can I see the parties on Munoz? Oh, just have a seat, Mr. Munoz. All right, which case are you proceeding on?
The ag robbery.
Okay. And that is 8543, correct?
I believe so.
Okay.
8543.
All right, and how much time are you all asking for 1 year? 30 minutes? Okay. All right, 30 minutes each. All right, I'm gonna bring the jury in at 3.
Can I go to kind of quick forward real quick? I had a Zoom at 2:00.
At 2? Yeah, but make sure you're back here at 3.
Oh, obviously.
All right, thank you. So we're gonna start at 3.
Carol, can you put that in Bexar? Can you put that in Bexar?
Yes.
Just when they approach on Isaiah Gonzalez briefly.
Yes.
So here's the issue. One of his major concerns with the plea bargain, and he's interested in the plea bargain, is that he has 954 days in, and they're only anyway. There's gonna be, it's like a judgment satisfied. There's less time that that they're assigning to him. But he doesn't know how it works at neither do I, to be honest with you, how it works at TDCJ, like, when they get
Oh,
a
what's
guy.
gonna end up happening?
Yeah.
One or two things. Either they're gonna release him from the Bexar County Jail, or either they're gonna process him through the prison system and then release him
And
from
then
there.
release it from there, okay.
Yes.
So that's kind of how I figured generically it would work, but he's afraid he's gonna be languishing in there months while they're trying to figure out the time
No.
differences and all that.
No, they will not.
Okay.
All right, that doesn't happen in this court.
And he's just getting a little, I told him, I said, the judge's experience, all I have to do is approach if there's a problem. And
Yes.
he's a little bit on the paranoid side,
Okay.
but it's his life.
Yes, no,
Okay.
no.
I think.
All right, you're welcome.
Judge Boyd, Miss, I had told my attorney I want to speak to you. I had told my attorney.
All right, so yes, you'll be able to speak to me, but a jury is coming in for you at 3 o'clock. All right. Just wait till your attorney comes back. The aggravated robbery. Yes. They said the 8543. Oh, yes. I don't want to do that. Right. I should have worn gloves.
Well, you saw.
I do. We cannot laugh at Norma anymore when she does that. Oh,
My gloves.
get the gloves. Yes, you did, and we ignored it. We ignored it. That won't happen again. Well, I didn't make fun. I just ignored it. Oh, and Helen, on this, they're doing the paperwork, so.
Just may I ask first?
Oh, yes.
And I told the prosecutor I was going to ask, DWI plea with the 10-day jail, would you allow him to report on a date certain?
You can either do that, or because COVID is happening, I allow people to start it on GPS if they want to start it on GPS.
Okay,
So they have a choice, they can do GPS or they can do jail.
but you're okay not taking him into custody today, correct?
Yes.
Okay.
All right, everyone, the jury's coming in at 3 o'clock. So if you have something you want heard, you need to approach the clerk, have her pull the file so we can hear it. Otherwise, we'll be seeing you at a later date, which will be tomorrow. All right, can I see the parties on Felicia Cox? Is Mr. Cox in the back room? Yes. Oh, don't tell him I said Cox. I do that a lot with Cleophas and Cornelius, yes, and it's because of the same name, sorry, the first. And then her last name is Cox. That doesn't help me. All right, who's here? Robert Chevalier. All right, what are we here for?
Your Honor, it's a motion to allow travel.
State, are you in agreement with this or no?
No, Judge.
All right, we'll go on the record. Court is calling 2020 CR 3796, State of Texas versus Robert Chevalier. Can I have parties announced for the record for the state,
Michelle Hayden for the state.
for the defense?
Sean Simpson for the defense.
All right, the court is in receipt of a motion to remit to travel while on bond. State, have you had a chance to review the motion?
I have, Your Honor.
State, are you in objection to the motion?
I am, Your Honor.
All right, state.
Your Honor, we just have one exhibit. I'm marking it right now. Prosecution guide in this case, and we're just offering it for purposes of this hearing.
Any objections?
I haven't seen it, Your Honor.
Thank you.
It's just a brief narrative. No object, we don't have a way to also move these witnesses, and I just briefly saw that, so. But I am aware that just for the purposes of this hearing, Your Honor, the court probably.
Can you speak up?
The court reporter
I
couldn't hear.
couldn't hear you.
I would object to it being admitted in this hearing. I just saw it. I didn't have a chance to go over it. And there will be no chance to question anybody about some of the statements going on.
All right, so I see that this case was indicted in 2020. State, has this been uploaded?
Yes, Your Honor.
All right, that'll be overruled for the purposes of this hearing only.
Thank you, Judge.
And just give me a moment while I review it. All right, the court will hear argument. State.
Your Honor, the state is uneasy with the idea of defendant traveling for leisure for, I believe it's the 4th of July holiday. He's accused of molesting 2 children in this case, as the court can see in the prosecution guide that's been submitted to the court. And he's also previously been granted deferred adjudication for an indecency with a child case from 1991. So for those reasons, this isn't a work trip. There's no other real legitimate reason for him to go there. The state is uneasy with it.
Your Honor, I did let the state know that this is a family reunion. It's not just the 4th of July. This is the 12th or 13th year that they have gone to this family reunion. It's a small one. It is his wife's parents are still alive, and they rent a house and they stay there for that week. It's her brothers, and there's no young children at this. The youngest person there, I believe, is going to be 15 years old. Everybody else is adults. And
there are no children in the family reunion?
it's correct, Your Honor. It's just the immediate family, the wife's immediate family.
Maybe it's just me, but I don't understand how there's a family reunion and there are the youngest child is 15.
Because everybody's older, Your Honor. His wife's family, I can call her up and ask her the questions of who's who.
Yeah, let's call up whoever you wish to call it. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, so help me God.
All right, can you lower your hand and could you make sure you can keep your voice up so that the court reporter can hear?
Oh.
All right, can you state your name for the record?
Jennifer Chevalier.
All right, who's at this family reunion?
It will be my mother, my father, my two brothers, and my brother's daughter, who's 17, and my sister and her husband, and their 21-year-old daughter, and their 15-year-old son.
All right. So say, here's my question. He's traveling for a family reunion. I mean, I know what he's charged with, but he hasn't been found guilty. Why, what's the difference of him not traveling and being here?
Well, according to his bond conditions, I don't know that there is necessarily much difference, but
I mean,
I'm honestly surprised that there weren't additional bond conditions initially imposed. In the case as
okay,
well.
and that was, of course,
Yeah,
was
of
someone
course, yeah, it
else.
was transferred from another court.
All right. Would anyone have any objection if, and which court was this transferred from?
I believe it was the 226.
Okay. Would anyone have any objection to, say any objection to the court allowing him to travel for this limited amount of time, but to impose, which I don't know if it's been imposed in any other bond condition, that he's not to have any unsupervised contact with minors?
I would be okay with that.
All right, and that means that the 15-year-old is a minor, so he cannot be along with the 15-year-old. Does everybody understand that?
Yes, Your Honor.
All right, so I'm going to explain something to you, Mr. Chevalier. When cases come to me, I only know what you're charged with. I don't know if it's true or not. Nobody's presented information to me. And the state did enter the prosecution guide for this, for purposes of this hearing only. Again, I understand that you didn't get a chance to cross-examine anyone, so I'm not taking it as necessarily true. I know this is what the state is tendering to me, so I can have an idea of what the entire case is about. And I don't want him around any minor children, all right, unsupervised. So I'll grant it, but I'm going to alter and amend, well, not alter and amend, but I'm just going to add, because I don't think it's in there, that there's to be no unsupervised contact with any minor. And if it's not a part of his bond conditions, which I guess it appears that it is not, as a part of his bond conditions, he is not to have any unsupervised contact with minors. Does everyone understand? Now, if something ends up happening and you end up having unsupervised contact with minors, and I find out about it through a motion from the state or whomever, we're gonna have some issues. And there may be a possibility that your bond, or at least that I'll issue a judge's warrant. You understand?
Yes.
And what that will mean is a judge's warrant will be issued and you'll be placed in custody until we have your hearing. Do you understand?
Yes, sir.
All right, is there anything else?
No further, Your Honor.
All right, Norma, when is this case set? Is it June 30th?
It is, Your Honor.
Yes.
All right, so it's set for June 30th. Okay, if there's nothing else, then you are excused. We'll see you on June 30th. Michael Campos. Oh, I'm sorry, could I have that exhibit? I left the exhibit in the file. All right, who's here on Michael Campos? Oh, defense counsel is, okay. All right, what date? Okay. All right, Mr. Campos, come forward. All right, your defense attorney is out ill,
Yeah, he just notified
and
me.
this was a setting for pre-deadline date. So I'm gonna extend your pre-deadline date and just a 30-day reset, Ms. Ferguson. All right, your reset date is going to be July 11th. Do not leave. Ms. Ferguson will give you a reset form.
Yes.
I thought we'd already done that.
Hi, we needed in the 187, so we can do this, plea. We're about to start a jury trial. Thank you. All right, are the parties ready on Felicia Cox? All right, where's Felicia Cox?
I was sitting in the gallery.
Where's your client?
She's right, she's sitting right there.
Is there a reason somebody's not coming forward?
Miss Cox, come forward.
You, Judge.
I'm telling you, that's
All
true.
right,
Judge. It's really
yeah.
true.
All right, and you need to go over here. Your client is in the middle.
I'm afraid.
You're so funny. All right, court is calling 2019 CR 5820, State of Texas versus Felicia Cox. Could I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Cleophas Marshall.
And are you Ms. Cox?
Yes, ma'am.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discoveries. Ms. Cox, I'm showing you what's entitled Application for Community Supervision of Deferred Adjudication. Did you review that document with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, I do.
State, are you proceeding on the indictment as presented?
No, Judge, I believe we're proceeding on count. Paragraph A, waiving paragraph B.
Any objection?
No objection, Your Honor.
Ms. Cox, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand what you're charged with is aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you are giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court would grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, she has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do believe she's mentally competent to stand trial.
Do you believe she's was sane at the time of the offense?
I do.
Ms. Cox, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Caroline, you can take this one back. That's done. Court will find that defendant has knowingly and voluntarily waived her right to jury trial, showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count 1, paragraph A only. There's a $1,000 fine to be probated. Affirmative finding of deadly weapon. State recommends deferred adjudication. There's to be restitution of $200 to Amber Times, Times. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
That is correct.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No.
Next, I'm showing you outside the plea bargaining agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There'll be a TAP evaluation, 150 hours of community service restitution, and anger management. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to count 1, paragraph A, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, state offers state's exhibit 1 and its attachments.
We reviewed the state's exhibits. We have no objections.
Ms. Cox, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Excuse me, off the record. That's not filled out correctly. All right, Ms. Cox, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form, thank you, of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Have the court for deferred finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, we are, Your Honor.
Anything you wish to say on behalf of your client?
Yes, I've had an opportunity to represent Ms. Cox in this matter, and she is requesting that the court grant her application for deferred adjudication. I would show the court that she's taking care of her disabled child, and so we would ask that the court would consider lowering the hours of community service or adjusting them. for that
Okay, you said
cost.
she's taking care of a child.
Yes.
All right. So is there anything you wish to say, Ms. Cox? Well, what's going on in your life? Why would something like this happen?
I don't know. It was New Year's.
I'm sorry, I can't hear you.
It was New Year's.
And how old is your child?
He's 10
And where was your 10-year-old doing this? It happened during New Year's and
with my mom.
see, if we would put our children first, maybe we wouldn't be here, right? So if you're drug tested today, what are the results going to be?
I was there.
All right, what are you going to be positive for? And what else? All right, you're going to get drug tested today. So you want to stick with just marijuana?
Says marijuana.
All right, so here's the thing. If it's more than marijuana, we're gonna have some issues because you're being dishonest with me. When I place people on probation, my goal is for them to be successful on it. So if you don't,
If I
yes.
may, Your Honor, there's always a possibility that somebody. could
All right, well, let's do
replace it with
this.
something.
What's the possibility that you may be positive for something other than marijuana? Because maybe somebody put something in a cigarette that you didn't know about.
Maybe cocaine.
All right, so there's a possibility that it may be cocaine, and what else? That, again, that someone may have put in a cigarette that you know nothing about. Okay, so cocaine, meth, and marijuana, and what else? Are you sure? All right.
They're always lacing the stuff with fentanyl as well.
Oh, that could be other things, you know, it could be other things. Okay, all right. Because I don't, we have drug testing that we can do here today. And we can get an answer from me right away. But I don't like to spend money unnecessarily if we don't have to.
I understand.
All right, are you employed?
No, ma'am, I take care of my disabled son.
All right, so we're gonna have to come up with a better plan because I can't have someone who may be on marijuana, cocaine, and methamphetamine taking, well, I don't know why you're rolling your eyes at me.
Your Honor, if I may, I think it's an unnatural or a natural demeanor or disposition of her. She tends to do it at all times.
Okay, here's the thing. I understand, and I understand that people make, no problem. I understand that sometimes people are nervous, but I can't have her until we get this drug problem under control. I can't have her having unsupervised contact with a 10-year-old. So you're not going to be allowed to be alone with him. You understand?
Yes, ma'am.
So I want you to be honest with me. Are you really taking care of him, or
Yes,
it's his
ma'am.
grandmother?
No, me.
All right. So does his grandmother know all this that's going on in your life?
No, ma'am.
All right. So do you have a significant other in your life?
No, ma'am, it's just me.
All right. So this is what the court is going to do. It's going to be 2 years deferred adjudication, $1,000 fine, probated. I'm going to want her in felony drug court. You're going to be referred to felony drug court. And this dancing that you did with me about something that may or may not be in a marijuana cigarette, don't do this with them.
Yes,
Just be upfront and honest with them because you really need the help. Because otherwise, you know what's going to end up happening? You're going to end up losing custody of your son. Okay?
Yes, ma'am.
So I want a referral to felony drug court. I'm going to want the UA hotline until accepted. And can you let felony drug court know this is an emergency?
Yes, Your Honor.
There's going to be $200 restitution and no contact with Amber Times.
Your Honor, if I may, on a no contact with Ms. Times, I've had an opportunity to talk with her, as have the state. In fact, she's in the courtroom at this time, and she is okay with there being a no harmful contact in the injurious, or no contact in a harmful or injurious manner. They do kind of flow in the same areas, and so I would not want.
Where's Ms. Times?
Ms. Times, would you please stand up?
Ms. Times, there should be no contact. We can't have people stabbing people in a neighborhood because let me just tell you what ends up happening. There's some person who's minding their own business in their neighborhood, just probably trying to have a relaxing evening, maybe barbecuing or something. And then they have to deal with all this foolishness with screaming and stuff going on and people saying, I stabbed somebody because they disrespected my company. So there's not to be any contact. All right, thank you. So there should be no contact with Amber Times, $200 restitution. Ms. Times, do you still want your $200 restitution? That could probably help her out.
Yes, ma'am.
All right, so she still wants her $200 restitution. We're gonna do parenting classes. There should be regular reporting and probation. I'm sorry to do this to you, but I'm gonna need field visit 4 times per month to make sure that her child is okay and that she's not having unsupervised contact. There should be no unsupervised contact with minors. I'm gonna want proof of employment within 30 days. There should be no employment as a home health care provider or minors. How are you supporting yourself?
I take care of my son, so it's on Social Security.
Yeah, that Social Security is for your son. It's not for you.
I know.
So, okay. I'm gonna want 150 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, and you present proof, 40 of those hours will be waived. The remaining of the hours will be waived once you provide proof of successful completion of parenting classes. If she's not accepted into felony drug court, please let me know immediately. We're going to do something else. All right. I tell you what, just go ahead and do a tap as well. All right, probation, is there anything else that she needs?
No, Your Honor.
I'm sorry, did I say report? Yes, I did say regular reporting.
Yeah.
Is there anything else you need from the court in order to be successful? All right, I'm gonna show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, you're gonna have to do better for your child. State, what are you doing with 2020 CR 4845?
Judge, it will be dismissed, but not sure in what form, but we plan to get rid of it
All right, when is that gonna happen?
today.
All right, thank you.
And Judge, we have impact statement, so
Is this an impact statement from the person who wants to have contact with her?
she doesn't want to have contact. She didn't care either way. Was
Oh, there's no, she says she has nothing she wants to say. Is that
No.
correct? Thank you, Ms. Tynes. Have a great day.
Thank you.
All right, thank you. All right, that will be all. Probation will go over conditions with her.
Thank you very much.
Court is calling 2022 CR 1929, State of Texas versus David Rodriguez. I have parties announced for the record for the state.
Brittany Sparks and Lorraine Ephraim for defendant, we're ready.
And are you Mr. Rodriguez?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery and did you review it with your client?
Yes, Your Honor. I did have a breath test order in place, but we have discussed it thoroughly and want to enter the plea, even though the breath test material is outstanding. So I
All
just
right.
wanted to put that on. the
Thank
record.
you. Court will find that the state is in compliance with discovery. Mr. Rodriguez, I'm showing you application for community supervision. Did you review it with your attorney? Did you understand it?
Yes, ma'am.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Rodriguez, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with driving while intoxicated third or more? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes,
Did you understand by entering this plea bargain agreement, you were giving up those rights?
yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case? Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Oh,
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent, was legally sane at the time of the offense?
Yes, ma'am.
Mr. Rodriguez, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
no, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 4 years in the prison. There's $1,000 fine. State recommends community supervision. There's to be restitution payable in 2022 CR 1921. Defendant will provide insurance documents, including fault determination. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense is at the plea bargain agreement.
Yes, Your Honor.
State.
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you cite it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel debating such motions.
And just the discovery motion I discussed, otherwise, no.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your community supervision be for a term of 4 years. There'll be a TAP evaluation, 150 hours community service restitution, 2-year Texas driver's license suspension, 10 days at the Bexar County Jail, ignition, interlock, full term DWI intervention, and VIP life. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Judge, State Offer States Exhibit 1 and all attachments.
No objection, Your Honor.
Mr. Rodriguez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor. please.
Anything you wish to say on behalf of your client?
Judge, he's very motivated to be successful on probation. He's brought with him one of his AA papers that he gets signed for meeting attendance. He has another one he didn't bring today, but I wanted the court, and I don't know if the court wants to see it, but
sure.
He's been actively engaged in maintaining his sobriety, and we believe he can be successful on this probation. So we're just respectfully asking the court to follow the plea bargaining agreement.
All right, Mr. Rodriguez, are you employed?
Yes, ma'am. I actually, self-employed. I work for myself and I do a lot of subcontracting.
Have any children?
I have 6.
What are their ages?
From 25 to gonna be 7.
All right, this is what the court is. Well, with regards to the 10 days at Bexar County Jail, do you, and I'm only giving you this choice because of health reasons, do you prefer to do it on GPS or do you prefer to just do your 10 days at the Bexar County Jail? If you do it on GPS, it's going to be extended from 10 days.
I'll just do the 10 days.
All right. You're going to have to report then on no later than Monday to begin your 10 days. Do you understand?
Okay. Yeah. Yes, ma'am.
So that will be the 27th.
Is there a weekend possibility to do the time on weekends?
No, they'll have to do that straight.
Okay.
All right, 10 days in the Bexar County Jail as a condition beginning on June 27th. You need to turn yourself in at the jail. And that's going to be by 9 a.m. 2-year Texas driver's license suspension. Ignition interlock. Full term.
Is that something that the court can revisit at a later date, the time, the length of the?
Yes, I'm always open to reconsider because that's outside your agreement.
And there's 2 things that I wanted to ask the court about at the appropriate time.
All right, VIP live, DWI intervention, regular reporting, in person or by Zoom. I want a referral to felony drug court. I'm gonna want parenting classes. And once you complete parenting classes, the remaining of the community service hours will be waived. Probation, is there anything else that he needs?
Your Honor, are we going with the 150 community service hours?
Yes, 100, I'm sorry, I wrote it down but didn't say it. 150 community service hours, restitution service hours. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get it, but if you do and you provide proof, 40 of those hours will be waived. The remaining of those hours will be waived once you complete parenting classes. Proof of employment within 30 days. No employment as a home health care provider or with minors. 10 days in the Bexar County Jail. That's again on June 27th. You need to turn yourself into the jail by 9 a.m. Anything else?
Say anything about UAs or field visits?
You are so, thank you.
We'll
You can
waive-
tell.
we'll waive those. We'll
Yeah,
waive.
you're gonna waive those. So we're gonna do regular UAs and we're gonna do field visits one time per month. All right, now is there anything else?
No, fine, right?
No, fine.
May,
Is there anything else you need from the court in order to be successful?
well, couple things, Your Honor.
Yes.
Number one, he'd like to switch the interlock device from the car that he has it on now, which is not operational, to another vehicle. I do not necessarily think the court needed to intervene on that. Okay, then the other thing on the restitution, I just wanted to be clear. Yes, this is a DWI that he has pled to, but the actual, and there was a 2-vehicle accident involved, but the insurance determination was that the other vehicle was at fault. The insurance company has actually paid him, the other driver's insurance company, and he has documentation to that. So I just want to be clear that we're not acknowledging fault in
No,
any way.
part of it is your client will have to provide proof of the resolution. So probation, if the resolution is that the accident was not his fault, then he won't owe restitution.
Okay.
But if the resolution is that the accident was his fault, he will owe restitution. Do you have that probation?
Yes, ma'am.
All right.
And that's why I added that little bit of language on the plea agreement about the fault determination.
All right, I'm gonna show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Because this is plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Kevin Castillo, good luck to you.
Thank you, Judge.
And wait a minute, before you leave, we're off the record. I want to explain something to you. This is your third DWI. And let me just tell you, my experience as a defense attorney and prosecutor, you know what ends up happening when there's an accident? Usually the person who's intoxicated, they're just fine. The people who end up having problems are the soccer mom, the grandmother, the grandfather, just out trying to enjoy their life. And your attorney said you do well on probation. Well, you do, but you're gonna have to transfer that part past just being on probation. When you're not on probation, you're gonna have to do well. So you're one of those people who can't drink alcohol at all, so don't do it, okay? All right, good luck.
I had one more thing I wanted to ask. That I know you said there's a 2-year suspension, and you said something about getting a job, I guess, a company job.
No, I said that you need to provide proof of employment. So whatever your employment is, you need to provide proof of it.
Okay,
All
okay,
right.
yeah, I was gonna ask, because
Okay, all right. Proof of self-employment you can provide. Okay. with
All right,
that?
everyone, we're gonna move it along because I have a jury in the hallway. Who's here for Kevin Castillo? Yes.
Mr. Judge, we have an agreement. We'd like to set it for Thursday. I'm going to plead him on misdemeanor in county court number 15.
All right, Ms. Ferguson
It's
on
recall for
Castillo.
Thursday.
Can we recall this on Thursday? All right, she's gonna give you a reset form. We'll be back on Thursday.
Thank you, Judge.
You're- All right, who's here on Juan Reyes? Please come forward. Court is calling 2017 CR 2184, State of Texas versus Juan Enrique Reyes. Can I have parties announced for the record for the state?
Charles Bach.
For the defense?
Joel Perez, we're ready on.
And are you Mr. Reyes?
Yes, ma'am.
Showing you what's entitled Discovery Acknowledgement. Counsel, have you received all the discovery in this case, and did you review it with your client?
I have your honor.
Court will find that the state is in compliance with discovery. showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We're proceeding on count 5. We're waiving counts 1 through 4. No objection, Your Honor.
Mr. Reyes, I'm going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand that the state is proceeding on count 5, which is exposure, indecent exposure, child, third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargaining agreement with the state, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargaining agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargaining agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargaining agreement in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does, Your Honor.
Do you believe he's currently competent, was legally sane at the time of the offense?
In my opinion, yes, Your Honor.
Mr. Reyes, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea bargain agreement?
No, Your
Are
Honor.
you satisfied with the way you've been represented?
Yes, Your
Are
Honor.
you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, state is proceeding on count 5, recommending deferred adjudication, sex offender registration, TAP evaluation, sex offender conditions of probation. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense is at the plea bargain agreement.
Yes, Your Honor.
State is at the
Yes,
plea bargain agreement. Next, I'm showing you the paragraph entitled waiver repeal paragraph. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that the deferred adjudication be for a term of 4 years, and there is no contact with the complainant. Is that correct, state?
Yes, Judge.
All right, did you understand those are recommendations from the state and court does not have to follow those recommendations?
Yes, Your Honor.
Then to count 5, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
We offer State's Exhibit 1 and its attachments. No objection, Your Honor.
Mr. Reyes, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it and did you sign it
Yes, Your
in
Honor.
all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but mostly importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will accept into evidence States Exhibits 1 and attachments. And after reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. However, the court will defer finding you guilty as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just, Your Honor, no final convictions, nothing, no arrest previously, so we're asking the court to grant him this 4 years deferred adjudication, please.
All right. Anything you wish to say?
No, Your Honor.
Are you employed?
No, I'm a disabled veteran and employable.
All right, so what do you do in your spare time?
I'm always with my headache condition, Your Honor, so I'm mostly in bed and just trying to get out little by little.
Are you around any, are there any minors in the home?
No, my 18-year-olds and above.
All
Two
right.
children.
And Your Honor, he does suffer, and we had a competency examination, and in there, it lists all the medications, the VA treatment he's receiving. He suffers from very, very serious migraines, and he's totally disabled.
All right, this is what the court is going to do. 4 years deferred adjudication, Chapter 62 compliance. There's the regular reporting by Zoom. Oh, I didn't see you there, or in person. Proof of employment within 30 days, no employment as a home health care provider with minors, or proof of SSI or disability within 30 days. There should be regular UAs, field visits 2 times per month, and no contact with the complainant. And I believe you know the name of the complainant.
Yes. Ashley.
Oh, no, I don't, I haven't.
Oh,
I'm
okay.
just not
Sorry,
saying it on
sorry.
the record. That's okay.
I'm so sorry. Your Honor.
No problem. And there should be no unsupervised contact with minors. And he's to be supervised with the sex offender unit.
Thank you, Your Honor.
You're welcome. Probation, is there anything else he needs?
No, Your Honor.
Is there anything else you need from the court in order to be successful?
No, Your Honor.
All right, I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Your Honor.
You're welcome.
Judge, may I be excused?
Yes. For the parties, Michael Anthony Martin.
I am judge.
All right. And probation, this is no application. Court is calling 2022 CR 3078, State of Texas versus Michael Anthony Martin. Could I have parties announced for the record for the state?
Brittany Sparks.
For the defense?
Robert Mauer for defendant, Your Honor.
And are you Mr. Martin?
Yes, ma'am.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I have in both cases, Judge.
Oh, we're going on 2.
Yes, ma'am.
Just 1 second.
Agreement's the same on both.
All right. And counsel, all the discovery in
Yes,
both.
ma'am.
And each of the cause numbers, Mr. Martin, I'm showing you what's entitled True Bill of Indictment. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented in each of those cause numbers?
Judge, in cause number ending in 3078, we are going to move forward on count 1, waive count 2, and also waive the repeater enhancement.
Any objection?
No, Your Honor.
I'm sorry, could you repeat? You're going on count
Count
2?
1.
Count 1,
Yes, Judge.
waiving count 2 and repeater?
Yes, Judge.
All right, Mr. Martin, in each of the cause numbers, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review those documents with your attorney? Did you understand them? Did you sign them in all the appropriate places?
Yes, ma'am.
In 2022 CR 3078, you're charged with possession with intent to deliver a controlled substance coming in group 1, 4 to 200 grams. That's the first degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison. In cause number 2022 CR 4754, you're charged with felon in possession of firearm. That's the third degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow those plea bargain agreements. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering these plea bargain agreements, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in each of these cause numbers?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to these offenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Martin, has anyone threatened you, coerced you, or placed you in fear to get you to enter these plea bargain agreements?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
And each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Each of the cause numbers, I'm showing you the plea bargain agreement. Did you review those with your attorney? Did you understand them?
Yes, ma'am.
According to the plea bargain agreement, their punishment is to be assessed at 10 years in the prison. There's a $1,500 fine. There are no applications. Each case will run concurrent with each other. And each case will run concurrent with parole case out of Medina County. That's 1704012353 CR. And the state is taking in consideration Medina County case 21-01091.
That's correct.
Yes, Judge.
All right. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense is at the plea bargain agreement?
It is, Judge.
State is at the plea bargain agreement?
Yes, Judge.
And each of the cause numbers, I'm showing you the waiver of appeal paragraph. Did you review those paragraphs with your attorney? Did you understand them? Did you sign them in both places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements?
Yes, ma'am.
I'm sorry, just a moment.
Can you slow down just a little bit?
I will. I'm so sorry, Brenna. I am going to slow down. Because I need to slow down. I'm sorry, Brenna. And you've been smoking.
You're making my head spin.
Okay, I'm going slower. All right. So did you review the waiver of appeal paragraph with your attorney? Did you understand it and did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
All right. Then in cause number 2022 CR 3078 to count one, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And in cause number 2022 CR 4754, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State in each of those cause numbers, do you have any evidence to support the plea?
Yes, Judge. State offer states exhibit 1 and all attachments.
No objections on either one, Judge.
Brenda, am I slowing down now?
Yes, you're doing great.
Thank you. All right, in each of the cause numbers, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Then in each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after hearing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and in each cause number, the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
All right, anything you wish to say on behalf of your client?
Judge, I just asked the court follow the plea bargain.
All right. Then in cause number 2022 CR 4754, the court will follow your agreement, sentence you to 10 years in the prison, give you credit for any time served. There's a $1,500 fine. Time and money will run concurrent. This will run concurrent with 2022 CR 3078. And parole case 1704-012353 CR. And taking consideration 2101-091. And in cause number 2022 CR 3078. Court will sentence you to 10 years in the prison. You be credit for any time served, $1,500 fine, time and money concurrent. Concurrent with 2022 CR 4754. Parole case number 1704-012353. Taking consideration Medina case 2101-091. Right, is there anything else from either side with regards to sentencing in either of those cause numbers?
Not from defense, Your Honor.
In each of the cause numbers, I'm going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review those, Mr. Mallon? Did you review those documents with your attorney? Did you understand it and did you sign it? All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction in each of these cause numbers, you're not allowed to own or possess any weapon or ammunition. Do you understand? If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
30.
You get into that point, I know you've heard my speech before, you get into that point where more of your life is almost behind you than in front of you. So you got to start making better decisions, all right?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
You're welcome. All right, who has Michael Fernandez? How long is this going to take? How long are you anticipating?
Judge, I have two brief witnesses, just Mr. Fernandez and his spouse, maybe 20 minutes.
All right, so we're going to do a jury selection, and then when we take a break for them to make their strikes, then I can hear this.
Okay.
All right, thank you. All right. Okay, thank you. All right, so everyone, Mr. Hernandez, your client, Mr. Munoz, is he proceeding with his jury trial?
Yes, Your Honor, we would like to make a statement to the court before we go to great jury.
All right, come forward. Brittany, do you need to take a break?
I just need to run the restroom. but
Oh, go ahead.
you want this on the record?
No, we can, Mr. Hernandez, we'll wait for the court reporter to come back and then we can do that. All right, so we're gonna start jury in. Who's speaking to someone in the box? Who is it, Deputy Laura?
What was the lady in the back? It was just asking me something.
All right, are you in court today for a case?
I've been here since 8:30.
No, my question is, are you in here? Are you on the docket today?
I'm supposed to be, but you didn't.
What is your name?
Lydia Trevino.
All right, come up front and Ms. Ferguson will see if you're actually supposed to be here. And Mr. Jimenez, we're going to take care of your plea today after we do jury selection.
Your Honor. The truth is that he has backed out. The DAs are keeping it open till Thursday, but he's backed out. In terms of
Can you bring him in? Where is he?
I was thinking of back there with him. I can sit there and get a glass of water.
All right, thank you. Yes.
Mr. McDonald, I'm here on behalf of Jody Sawyer still. He has not appeared where he came from Corpus. He's the one who had the misunderstanding. He's on his way still. Can I have him come in tomorrow morning? He's done here today.
Yes, we'll be, we're still here. We're gonna pick a jury, so I will wait for him.
Okay,
But if
thank you.
he's not here by 5.
Okay.
All right. Yes.
Hi, Judge. My client, I think he was about 5 or 10 minutes late this morning, so I just wanted to make sure before we're released. We were on docket today for trial, but I'm assuming we can go and Norma will let us know or
Well,
not?
just a
No.
moment. We're gonna see what needs to be placed on the record with this.
Oh, okay.
All right.
So wait until then. Thank you.
Yes.
Your Honor, I have a bond set request unrelated to today's docket, but you are the judge and I'm the attorney. Can I at least hand this to you so that you can look at it whenever it pleases you? Thank you. It's an MTR
Oh, no.
on a
just-
listogram.
So we're getting ready for the jury selection. I'll look at it when I get it.
Thank you so much. We're just asking for bond set, very simple case.
All right. And what is your name, sir?
Isaiah Gonzalez.
Can I see that Isaiah Gonzalez? Norma, on Mr. Gonzalez, he's coming back on Thursday. That's your plea deadline date. I am not extending it any further. And if you decide that you're not going to accept the plea, then you'll be back the following week for jury trial. You understand?
Yes, Your Honor.
All right. Ms. Ferguson, can you give them a reset form for Thursday? All right. You're welcome.
Yes.
All right, Miguel.
Yes, Your Honor.
All right, you want to come forward?
Yes, Your Honor.
And Mr. Munoz, before we go on the record, is there something that you want to place on the record, Mr. Munoz?
Yes, before my jury trial.
All right, we're going to go on the record in 2019 CR 8543, State of Texas versus Eduardo Munoz. It's the court's understanding, Mr. Hernandez, and Mr. Munoz wanted something on the record.
Yes, Your Honor.
All right,
Yes, ma'am. I've
yes.
been asking my attorney who's supposed to file a motion to dismiss counsel. He told me he was gonna do it 2 months ago. When we
Let
came
me
back
ask
to
you
court.
something with regards to that. Mr. Hernandez, are you appointed?
Yes, Your Honor.
All right, so the court is not allowing him to be dismissed. Is there anything else you wanted to speak to
I
me about?
mean, and been 3 years, it's been on my case. He has no,
Yeah,
has
you're
not
going to
filed no
jury
motions.
trials. All right, we're done. We're gonna, jury's in the hallway, you're going to jury trial, okay? All right, thank you, Mr. Munoz. And if you all could, whenever you want him to sit over at the table, Deputy Mejia.
Yes.
Yeah, I gotta.
All right, and state on Munoz, I want to make sure I have it correct. You all are proceeding on the 2019 CR 8543.
Yes, Your Honor.
All right, thank you. Mr. Hernandez, I don't know if you've been in jury trial here or not. I can't, or It's been a long time. But so what ends up happening, I'll give the state 30 minutes, give you 30 minutes. And then afterwards, if you all can agree on strikes, then the court usually follows those.
Yes.
But I don't require you to strike a juror during voir dire.
Okay.
All right. It's all like this. Oh, yeah.
Mr. Warner.
Oh, is he done?
Uh,
I don't know, why are you giving me the thumbs up? Oh, that's for your attorney. All right, can you put us on mute, please? All right, everyone. Good afternoon. I know it's a late afternoon. Good afternoon, everyone. All right, it's late, but it's not that late. It's not past anybody's bedtime yet. Good afternoon, everyone.
Good afternoon.
All right. So you are in the 187th District Court. I'm Judge Stephanie Boyd. This courtroom is located on the 4th floor. So what court are you in? Which floor? 4th. And who's the judge? See, you know what the problem is? It always tails off when I get to that last part. So what court are you in? Which floor? 4th. Who's the judge? And you know why I asked that question? I asked that question every jury that we have up here, because you guys are turning off lights. Time to go home. All right. So the reason why I asked that question is because we have given jurors breaks, and then we're waiting for one juror to come back, and we don't know where that juror is. And that juror is down the hallway or either next door, because there's another court next door, on their jury selection. So if you ever get lost, you should remember you're on the yes, and I'm the only boy in the courthouse. So if ever get lost, if you just say 187 District Court, they'll tell you. Or if you say you're on the 4th floor, that'll jog your memory, and you will say, oh yeah, the 187. So you all have in your possession something that is very who's passed their phone up? All right, you all have something in your possession that is very expensive. It's the cards with your numbers on them. So if everyone could, if you could hold up your card number for me. All right, you can lower them. The reason why I asked you to do that is because whenever myself or the state or the defense asks you questions, if you want to respond to it, or if the question applies to you, before you speak, you need to raise your number and they'll acknowledge you by your number. Brenna is the court reporter. Can you raise your hand, Brenna? Brenna is excellent at what she does. I can tell you while you all were waiting outside, I was handling other cases that were not related to this because I still have a docket, even though we're in jury trial. And I started talking extremely fast. Brenna was still able to take down everything that I'm saying. She can do 2-3 people at once, but it's Tuesday. We were off Monday, and all that means is now Monday has to come Monday and Tuesday. So let's not make it a difficult day for her. We're all going to speak one at a time. This is the other thing I need you to do for me. And so far, no jury panel has been able to follow this rule. So pay close attention and please follow this rule. If you're in this box, which is called the jury box, or if you're on this front row, when you're speaking, you don't have to stand up. Brenna will be able to hear you. I'll be able to hear you. But the acoustics are not great in this courtroom. So if you're not on this row, that row in the jury box, or this front row, anytime you respond, you'll need to raise your card and stand when speaking. Does everybody understand? Yes. Is anybody going to forget? All right. So I've already introduced myself. I'm going to let the state introduce themselves, please.
Marcus Sanders.
And for the defense? All right. Does anyone know or recognize any of those parties who just introduced themselves? All right. So other than just meeting downstairs and maybe standing out in the hallway talking to each other, do any of you know each other other than just meeting? All right. What's your number, sir?
35.
All right. Number 35, who do you know?
I just know him by association with this gentleman.
All right. Does that gentleman know you?
Yeah.
Home Depot. Okay, 35. And sir, what's your number?
29.
All right, so 29. I don't know if he doesn't want to admit that he knows you, but you know him. Okay.
Yeah.
All right, thank you. Anyone else know anyone? All right, that's usually we get a lot of school teachers who have students, One time we had the wife and the ex-wife. So they were all nice. Everybody was fine that they were the ex-wife. Another person was fine that they were the wife. All right, so we're here. Mr. Munoz is charged with the offense of aggravated robbery. I just want you all to think about that for a moment. And I'm sorry, Mr. Hernandez and State, could you come forward, please? All right, so I just want you to think about that charge for a moment, and the state is going to ask you some questions and the defense is going to ask you some questions. So any questions that I ask of you, any questions that the state or the defense asks of you, they're hypotheticals. They're not about this specific case. Neither the state nor myself nor the defense can tell you about any facts that they think that this case is about. Does everyone understand? Yes. All right. So when they talk to you, it's hypotheticals. Now, how many people here have had a traffic ticket? Don't be shy. Practice raising your cards, the expensive items. All right, so you can lower them. So I've had one traffic ticket in my entire history. It's when I was very young. And at that time, they actually gave you a sheet of paper. You sign it and it tells you what the charge is, and it tells you where you need to go to either pay the ticket, or if you want a jury trial, you can do that. Now I think they do it electronically. So let's assume you have a traffic ticket and they say that you ran a stop sign, don't know what a yield sign is, which a lot of people don't know what the yield sign is, or ran a red light, okay? When that officer pulls you over and gives you a ticket for that, and you accept that ticket, your accepting of that ticket is not saying you're guilty. Does everyone understand? Yes. And on that ticket, it'll tell you what you're charged with, and it'll tell you where you need to go to address that ticket. Now, when you accept the ticket, it's not an evidence of guilt. The fact that you've been given a ticket is not an evidence of guilt. That's just the police officer or whomever it is saying, I'm saying that you ran a red light. This is where you need to be in order to address that. Does everyone understand? Yes. All right. In felony cases, which is what this case is, you are brought to court through what's called an indictment. And an indictment is just a piece of paper, and it tells you what you're charged with, where you need to be. Does everyone understand? Yes. An indictment is not an evidence of guilt. It's just a way by which someone is brought to felony court. And you cannot and must not consider it as an evidence of guilt at all. Does everyone understand? Yes. Is there anyone here who feels like, I understand that's the rules, but I'm not following that? Okay. Now, has everyone seen crime shows? Yes. I'm aging myself. Beretta, Mannix, Barnaby Jones, The Practice. Okay, only a few people have seen that. But that's very sad. Or either other people too embarrassed to admit it. So, does everyone understand the right to remain silent? Is there anyone here who hasn't heard that? So the right to remain silent, what that means is you don't have to give testimony against yourself. So in criminal cases, you don't have to testify on your behalf. Does everyone understand that? And if someone chooses not to testify on their behalf, anyone who's accused who chooses not to do that, you can't hold it against them and you can't consider it. Does everyone understand? Yes. So is there anyone here who's going to be unable to follow that? So if Mr. Munoz were to decide not to testify, you cannot hold it against him. Does everyone understand? Yes. Can't consider it. Does everyone understand? Yes. Don't be like Mrs. Kravitz on Bewitched. Does everybody understand? Yes. Again, only a few people get my examples. Brenda, have you ever even seen it?
I don't know.
See. All right. So the other thing is everyone is presumed to be innocent unless and until proven to be guilty. Does everyone understand? So when people come in the courtroom and they're charged with an offense, again, that's not an evidence of guilt, and they are presumed to be innocent. Now, the person who has to prove each and every element beyond a reasonable doubt is the state. Does everyone understand? All right, the burden of proof is proof beyond a reasonable doubt. When I graduated from law school and tried my first case in 1997, there was a definition for proof beyond a reasonable doubt. We had to know it forwards and backwards. I knew it forwards and backwards, used it in my first jury trial. And guess what? After I used it, law changed. There is no definition for proof beyond a reasonable doubt. So when I was a defense attorney and when I was a prosecutor, how I would explain it to people is what it was not. So next door is the civil courthouse. They have burdens. One of their burdens is preponderance of the evidence. More likely than not. Has everyone heard of that before? Proof beyond a reasonable doubt is a higher burden than that. The other burden they have on the civil side is called clear and convincing evidence. Clear and convincing evidence is the burden that's used to terminate someone's parental rights. That means tell you you're a bad parent, you've placed your children in danger, and we're no longer going to let you be the legal parent to a specific child. Does everyone understand?
Yes.
Proof beyond a reasonable doubt is a higher burden than clear and convincing evidence. Now, there are two phases to a jury trial. The first phase is what's called guilty or not guilty. Some people refer to it as innocent or guilty, but really the phase is guilty, not guilty. And in that phase of the trial, a jury or a court will listen to evidence and make a determination whether someone's guilty or not guilty. Does everyone understand? In Texas, you have two phases for a jury trial. The second phase is punishment. You only get to the punishment phase if someone is found guilty. If they're found not guilty, of course, there's no punishment phase. Our law states that anyone who's on trial must make a decision on whether or not they go to the court for punishment or the jury for punishment if they were found guilty. Making a selection or an election is not an evidence of guilt, and you must not take it as an evidence of guilt. The law requires that a defendant must make that election before a jury trial. Does everyone understand? In this case, Mr. Munoz has decided if he were found guilty, he would go to the jury for punishment. Is there anyone who's going to hold it against him or think that this is some way stating that he's guilty because he's made an election? Now, the state is going to talk to you about a one witness rule. And I'm going to give you a hypothetical, the one witness rule. Do not add anything else to this hypothetical that I'm going to give you. So what do I mean by that? Don't in your mind say, I wonder if the hypothetical the judge is giving me, was it raining? Was it dark out? Was everybody wearing the same clothing? No. The hypothetical I'm going to give you is the hypothetical. This is the one witness rule. One witness comes to testify. And again, it's not about this case, it's about any criminal case. They're sworn in to tell the truth. This one person, it can be Mother Teresa, it can be Pope John Paul, it can be whomever you think it is. But the key is that one person who's called to testify testifies, and they prove the state's case. They prove every element that the state has to prove. There's no issue with credibility. You believe them. There is no, well, I wonder if they thought about this or if they thought about that. That's not in my hypothetical. My hypothetical is one witness is called, that one witness proves the state's case. Does everyone understand the hypothetical? Yes. All right, then the question becomes whether or not you would be able to find someone guilty based upon one witness that has no credibility issue with you and you believe them. Is there anyone who would not be able to find somebody guilty based upon that hypothetical I've just given you? All right. And with that being said, the next thing, and I never figured out how to ask this question. How many of you, or is there anyone whose English is not your primary language? All right, number 9. All right, usually we have more people than that. So what is your primary language, number 9?
Spanish.
Awesome. I think people who speak different languages, I just love listening to different languages. I had a classmate who spoke 6 different languages fluently, and I was just like, oh, teach me, please. Have you been able to understand everything that's being said?
Yes, ma'am.
All right. Now, the other thing, since if you were to get to punishment, is there anyone here who feels like they're not able to judge somebody? And when I say not being able to judge somebody, I mean that there's some deep belief you have that you can't sit in judgment of anyone. Is there anyone who feels that way? All right, 35. All right. So is there anyone with any, excuse me, could I get some water? Water. There's just some in the drawer. Everyone stay seated. Allergies, just a second. I'll just get some from the fountain. Sorry about that. Sometimes my allergies, as you can probably tell by my accent, I'm not originally from San Antonio. I'm originally from Louisiana, so I have very bad allergies here that I never had before. All right, so with regards to time constraints, is there anyone here who has a time constraint? And by time constraint, I mean you have travel arrangements and they're non-refundable and you can't transfer them to me. No. All right, let me see. Number 8, 18, 27, 17, 51, 73. Thank you so much. All right, number 8, what is your travel arrangement?
We're going to Kentucky in the next 2 weeks.
All right, what are you doing in Kentucky?
I believe, I'm not sure the date, but I can find out. We're going to travel to visit my family. And we've already done all the hotels, non-refundable, all of that.
And you say in 2 weeks?
I believe so. I'm not sure the dates.
All right.
A week and a half, 2 weeks, I believe.
Okay. Number 17.
I have a medical appointment tomorrow. I can't miss.
Okay. And what time is it tomorrow?
8:45.
27.
I'm traveling for business on Monday.
Where are you going?
Los Angeles for 1 week.
And is that for business?
Yes.
Okay. What are you going to do there?
I work for Best Buy and I'm putting on a technology camp for an underserved community.
All right. Thank you very much. Number 51.
I'm going out of town tomorrow, East Coast, Colorado, applying for a convention.
What convention is this?
Sorry, I'm traveling with my husband's kids.
All right. So you're just going along to enjoy the sights.
Yeah,
All right. And that's tomorrow?
yes, ma'am.
Is there still skiing going on there? Are you planning on doing that?
Yeah.
Okay. Number 73.
Maybe Saturday for 1 week vacation.
All right, where are you headed? I'm sorry, where?
Aruba.
Oh, thank you. I have a lot of water now. Thanks. I appreciate it.
Judge, I believe number 18 also raised their hand.
Yes, number 18.
I'm leaving Friday to Houston for work.
What are you doing in Houston?
I'm a stylist for a band.
Oh, well, which band would this be?
They're called Urban Heat.
Urban who?
Urban Heat.
Oh, okay. I have heard, the person in my age bracket, might I have heard of their music?
Probably not, but you should look them up. They're great.
Okay. All right. Anyone else? Okay. So I'm going to tell you 2 true stories. Then I'm going to turn it over to the state and defense. My uncle went to Vietnam. So he was from Grand Cane, Louisiana. He's since passed. He didn't, die from the war, but he's super intelligent. So he would get passed through grades, and they started the draft. So when they started the draft, he decided he wasn't going to be a sharecropper. He's not picking cotton. So he decided that he's going to go ahead and go, because they were drafting all of the young boys who were in Grand Cane. So he went to my grandmother, and my grandmother said, okay, fine, I'll sign up, give you the release so you can go. So he served in Vietnam. And I tell that story to everybody to tell you this. When you think about it, your country doesn't ask much of you, right? You don't have to serve in the military unless they change the law. There's no longer a draft. You don't even have to register to vote. When you think about it, one of the few things that your country asks of you is to take time out of your day, out of your schedule, to serve for jury duty. If we don't have jurors, we can't have jury trials. And so I always tell that story about my uncle, because even though they were having the draft, my uncle just chose to go ahead and sign up. Now, the other story I'm going to tell you is about one of my friends from law school. So she decided she wanted to do civil law. I've always wanted to do criminal law. It's been my passion. And so she gets this job, and we don't see much of each other. So one day she tells me that she has jury duty, and I'm like, hey, great, we can do lunch. So she's like, yeah, let's do lunch. So we get together for lunch. We're talking. It's like time has not passed at all. And then I asked her, how is jury duty going? And she tells me, fabulous, it's excellent. And I'm like, yeah, I think jury duty is great, but I've never heard anyone describe it as that. I'm like, why are you saying it's fabulous or excellent? She's like, I'm not going to be picked. I said, what do you mean you're not going to be picked? She's like, it's like law school. I'm on the back row, keeping my head down, not answering any questions. So I started laughing hysterically. And she's like, what's so funny? I said, you're so getting picked. I'm like, the solid ones always get picked. So lo and behold, guess what ends up happening? I see her at the end of the jury day, and I'm like, hey, how did jury duty go? She's like, I'm coming back tomorrow. I'm on the panel. So those are 2 true stories I've told you. So I hope you all keep those in mind. All right, State.
Thank you, Judge. Good afternoon, everyone.
Good afternoon.
I'm Marcus Sanders, Brittany Sparks. As the judge said, this is Ward Dyer. We also call it jury selection. It's our chance. It's our only chance where we get to talk to you. We get to have a conversation with you. The entire purpose is to sort of get your feelings on certain subjects. I can't go into the facts of the case, but really the main thing that we're trying to do is find out if we're the right juror for this particular case. And so all the questions that I ask, everything that comes up during this part of the trial, that's the purpose of that. Not trying to pry or get on business or anything like that. So the question is, can you be fair and unbiased in this case? Can you even give me an example of why someone would be able to be fair and unbiased in a particular case? Juror number 21. Why is it possible? Or what's the situation where someone would be fair and unbiased?
If they have like a deep belief in something, like if it has to do with something, if it's religion or it's a hard belief that they have, like abortion rights. If this is a abortion towards what they believe.
Yeah, that's a great example. example. She said if someone has a deep belief in something, where they have strong feelings towards it. Another reason, that's why the judge asked if anyone knew us, because if you know someone, that can be another reason. You're number 70.
Yeah, I can hear you.
Okay, I'll talk about it. Essentially, 56.
Question, when they say they know you, like, how do they mean know you, like personal or?
Okay, what was our rule about?
Sorry,
what-
you can stand up?
Yes,
Is it by personal or is it by situations that happen to know you?
Yeah, so ultimately, even if you know one of us, the question is, with that relationship, would you knowing one of us affect your ability to be fair and impartial for this case? So if you're best friends with someone, that's important for us to know because you probably can't be fair and impartial, right? 56.
The reason why I'm asking, because I know you guys by prior engagements.
Okay.
Court sessions.
And is that me and Brittany specifically? Okay.
So the reason why I know it's to her, I recognize her.
Okay.
You, I think you worked with her plenty of times, and unfortunately, I was gonna get upset.
Okay. So I guess your past experiences, would that affect your ability to serve on a jury?
Not on this case.
Okay.
Not on this case, but it may be on some other case because of the previous.
Okay. And my personal example, when I was a misdemeanor prosecutor, I was working late one night. I was parked on the street, and when I got outside, my car was broken into. Back then, I handled burglary of vehicle cases, and so every time I handled a burglary of vehicle case, I would think, is this the person that broke in my car? And so I would always tell myself, like, if I ever got called for jury duty, and if it's a burglary case, there's no way I would be able to be fair and impartial in that case, because I would be thinking, this could be the guy who broke in my car. And so when I'm asking you questions, I want you to consider that, consider those type of scenarios, like jury number 21 said, and see if there's anything that sort of strikes a chord with you. So we're trying to find out if you can be fair, if you can follow the law for this particular case. As juror number 21 said, let's say this was a possession of marijuana case. Does anyone know who that is? What about that person? That guy? And those guys. So, like juror 21 said, if you hold a belief that's so strong, of course, this isn't abortion or anything important like that. It's a possession of marijuana. But do you think that those guys would be able to be fair and impartial if they were called for jury duty on a possession of marijuana case? Yeah, very unlikely. And so if you're chosen for jury, chosen for this particular case, you're going to take an oath to render a verdict based on the facts and evidence that's presented. So the case we're here for is an aggravated robbery case. Before I can talk about aggravated robbery, we have to talk about theft. So there's legal definitions for most things. I'm going to give you the legal definition. If you're chosen on the jury, the legal definition will be provided to you, but I'm also going to break it down into plain English. The legal definition: a person commits an offense of theft if he unlawfully appropriates property with intent to deprive the owner of the property. Appropriate has a legal definition. Appropriation is unlawful if it's without the person's consent. So when you think of theft, what's the first thing that comes to mind for number 11? Stealing. Yeah. Any particular type of theft that came into your head? Yeah. Anyone? When you hear theft, what do you think of? Car theft. You're number 6.
Shoplifting.
Shoplifting. 27.
Money.
Yeah, stealing someone's money. Plain English is taking something that doesn't belong to you. So the first question I ask, and I'm going to go through, I'm going to ask you to raise your cards if you fall into each category. The question is, the value of the property taken does not affect how strongly I feel about the offense. Does that make sense to everyone? So raise your card if you fall into 1. So you strongly agree that the value doesn't matter. A theft is a theft, and I feel as strongly about it, no matter if it's a piece of bubble gum or a car. If we have 2, 3, 6, 8, 9, 11, 12. When I call your number, you can put your card down. 15, 17, 19, 20, 23, 24, 25, 26, 27, 28, 29, 30, 31, 33, 35, 36, 37, 43, 44, 46, 47, 48, 49, 50, 51, 52, 53, 54, 57, 58, 59, 60, 61, 62, 63, 64, 65, 66, 68, 69, 72, 73, 74, 75. Who here slightly agrees with that statement? 13, 7, 10, 14, 16, 18, 21, 22, 32, 38, 40, 41, 55, 56. Who here slightly disagrees with that statement? 45 and 71. And who here strongly disagrees? So the value does matter to you. At 39. That's it. So now that we know what a theft is, let's talk about a robbery. A person commits an offense if in the course of committing theft and with intent to obtain or maintain control of the property, they intentionally, knowingly, or recklessly cause bodily injury, or they intentionally or knowingly threaten another and place them in fear of bodily injury. Sorry, or place them in fear of bodily injury. And so, in the course of committing theft, it has a legal definition. In the course of committing theft means conduct that occurs in an attempt to commit, during the commission, or in the immediate flight after the attempt or commission of the theft. Breaking it down, if I'm going to take something, someone tries to stop me, and I assault them either by punching them, causing some sort of bodily injury, or threatening them, that's a robbery. Does that make sense, everyone?
Yes.
So if you're number 29, if I try to take your water bottle and you take it back, and then I punch you, is that a robbery?
Yes.
Now let's say if you're number 29, if you don't give me that water bottle, I'm stab you. Is that a robbery?
Yes.
Let's say I take it and I run away and he tries to grab me and then I threaten him. Is that a robbery? So intentionally knowing or recklessly caused bodily injury to another, or intentionally knowing, threatening, or placing another in fear of bodily injury. And what's important for this, for that second definition is the or. So either threatening someone, or if I actually place them in fear. So even if, let's say, I say juror number 29, was it 29? Yeah. If I say I'm going to stab you, me threatening him is a robbery, or if he's placed in fear, that's also a robbery. Does that make sense? It doesn't have to be both. Bodily injury has a legal definition. It means physical pain, illness, or any impairment of physical condition. It does not require visible injury. The victim can testify to pain and suffering. Would everyone agree with me that not all injuries are visible? Like a concussion, there's something internal going on, you're not necessarily going to see a visible injury. Does that make sense to everyone?
Yes.
Next question for y'all. Same thing is going to be strongly agree, slightly disagree, or strongly disagree. Robberies where there's only the threat of injury are just as important as robberies where there is an actual injury. So if you're a 1, if you strongly agree that robberies are just as important, whether it's a threat of injury, whether it's me saying juror number 29, I'm going to stab you, or if it's me punching juror number 29, those are equally important. Raise your card if you strongly agree. We have 2, 3, 6. Yes. Yes, sir. No. 8, 9, 11, 20, or sorry, 12, 13, 14, 15, 16, 17, 18, 19, 20, 22, 23, 24, 25, 26, 28, 29, 30, 31, 32, 33, 35, 36, 37, 43, 44, 50, 51, 52, 53, 54, 55, 56, 57, 58, 61, 62, 65, 66, 68, 69, 70, 72, 74, and 75. Who here slightly agrees with that statement? 6, 10, 21, 27, 38, 39, 46, 47, 48, 49, 59, 60, and 64. Who here slightly disagrees with that statement? 7, 40, 41, 45, and 73. And who here strongly disagrees with that statement? So now that we know what a theft is, we know what a robbery is, what makes a robbery aggravated. Jury number 7, would you have a guess at what makes the robbery aggravated? Well, so there's gonna be, well, that's gonna be a robbery if there's an assault with actual harm or threat. So we need something to bump it up to that next level. Jury number 19.
I can't hear you.
Maybe coming with a gun or a weapon.
All right, let me ask, who's juror number 19?
He was on the phone.
All right, so if you could make sure you speak up just so Brenda can hear. Oh, no problem.
Yep, jury number 19, that's correct. That's one way, if someone has a gun or some sort of weapon. It's actually 2 ways. So, or there's 3 ways, but there's 2 that we're gonna talk about. A person commits an offense if he commits robbery as defined in section 2902. Neither causes serious bodily injury to another, and that has a legal definition. Uses or exhibits a deadly weapon, and then there's the 3rd way where if the person is over 65 years or disabled, but that isn't applicable. So let's talk about that second way. If they use or exhibit a deadly weapon. Deadly weapon has a legal definition. Deadly weapon means a firearm or anything that in the manner of its use or its intended use is capable of causing death or serious bodily injury. Serious bodily injury has a legal definition. Means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. So, broken arm, would that be serious bodily injury? Someone had to be like metal plates, would that be? What if they had like a punctured organ? Would that be serious bodily injury?
Yes.
So let's talk about some weapons. Is that a deadly weapon?
Yes.
What about that?
Yes.
That?
Yes.
That? Yeah, those all could be deadly weapons. The gun is per se a deadly weapon. The other 3, depending on how they're used, deadly weapons. Another thing I would mention is use or exhibit. There's no legal definition for use or exhibit, so I'm going to give you some examples. Is firing a gun at someone, is that using or exhibiting a deadly weapon? Yes. What about just pointing at? Sorry.
Not necessarily.
I can't see you or hear you.
Not necessarily if it's self-defense.
Well, you would still be using or exhibiting it, right? Now, whether it's self-defense or not is another question, but you're still using that in self-defense. Pointing a gun at someone, is that using or exhibiting?
Yes.
What about holding a knife up to someone, is that using or exhibiting?
Yes.
Swinging a bat at someone?
Yes.
And this is what I mentioned earlier, where if there's a legal definition for a word, it'll be provided to you if you're chosen on the jury. If there's not, then you're just supposed to use the ordinary meaning of the word. So if you're chosen on the jury, and maybe already you may have heard us talk about elements. Elements is just how we're trained in law school. It's how we break down the law. It's how we lawyers make sure that we prove everything that we need to prove. And defense, they attack certain parts. And so it's just the law breaking down into parts that make it easier for us to explain y'all what it is that we have to prove. So the elements of theft, this is what we have to prove. The burden's on us to prove that on or about a certain date in Bexar County, Texas, the defendant unlawfully appropriated property with intent to deprive the owner of property. We talked about that. I gave you the legal definition. This is just it broken down. Robbery, on or about a certain date in Bexar County, Texas, the defendant, in the course of committing a theft with intent to obtain or maintain control of the property, intentionally or knowingly threatens or places another in fear of imminent bodily injury or death. That's what we discussed also. Lastly, elements of aggravated robbery, on or about a certain date in Bexar County, Texas, the defendant commits a robbery and uses or exhibits a deadly weapon. Does that make sense, everyone? Is everyone clear on what we, the state, have to prove, the elements? Does anyone have any questions? So there's some words that were used intentionally or knowingly. That has a legal definition. This is the legal definition. It's long. I'm not going to read it to you. This is how sort of layman's terms, but then I'll sort of break down some more. Intentionally, it is your objective to engage in a conduct or cause the result. Knowingly, you are aware of your conduct or understand that the consequences of your actions are likely to cause a result, and then recklessly conscious disregard of harm that might be caused by your actions. So intentionally, let's say juror number 11. Let's say I said juror number 11, I don't like the way you're looking at me. I stare at him and then I throw this clicker at him. Was that intentional? Yeah. How do you know it's intentional? If you're number 6, I look at him. You're number 17. How do you know it's intentional? Yeah. You're number 16. Anyone else? 15? You said you saw me do it? You said you confronted him before doing it. Yeah, I said juror number 11, I don't like the way you look at me. Anyone else? Juror number 21? I pointed it at him and then I threw it. Yeah, all of that goes to show that it was intentional. Now, knowing, let's say I don't say anything, but I still look at him, I sort of like squint my eyes, and then I look at him and I throw it. Was that intentional? Yes. Yeah, most likely, right? Was it knowingly? Yeah. And you know that it's knowingly because I looked directly at him and then I threw it, right? Now, let's say instead of picking on juror number 11, I just looked at all of y'all all cramped in and I just threw this out there. Now, let's say I hit juror number 41. Was it intentional for me to hit juror number 41? Yeah, probably not. Maybe. Was it knowingly? Depends how good of a good I'm throwing, right? Was it reckless though? Yeah, exactly. So, how do we prove someone's mental state? By statements, by actions, and by the surrounding circumstances. What we don't have to prove, anything that wasn't one of those listed elements. So anything that's not on or about a certain date in Bexar County, Texas, the defendant commits a robbery and uses or exhibits a deadly weapon. The most common question that we get is why a particular person does something. The reason that we don't have to prove that is because a lot of times we don't know. No one's in that person's head. And so we're only required to prove those elements that we can prove by law. Does that make sense, everyone? Is anyone going to feel a certain way or feel like they wouldn't be able, they would hold us to a higher burden and require us that we prove why someone did something? As the judge said, the burden of proof in a criminal case is beyond a reasonable doubt. There's no legal definition for it. All we can tell you is what it's not. It's not 100%. It's not removing all doubt. It's not beyond all possible doubt or beyond a shadow of a doubt. It's beyond a reasonable doubt. It's the same burden that's used in criminal cases across the United States, from traffic tickets to murder cases. It's a high burden. It's one that we gladly accept, but it's not an impossible burden. And it's one that we intend to meet. So let's talk about the types of evidence that you can expect to see. Evidence is anything that comes from the witness stand. So any witness that takes a stand, that they take an oath, they swear to tell the truth, that's evidence. So there could be a victim, there could be police officers, there could be eyewitnesses. That would all be evidence. There could be physical evidence, such as videos or photos, and other physical evidence, such as, like, let's say it was a robbery case, gun, fingerprints, getaway car, things like that. All of that's considered evidence. Anything that's admitted as an exhibit is going to be evidence, and it's going to be something that you can take back with you and consider if you're chosen on the jury. We'll remind you later, one thing that's not evidence and won't be admitted is if there's any police reports, those can't be admitted, those aren't evidence, there's rules against it. So if you're chosen on the jury, it'll be in the instruction, but that's the one thing that's not evidence, but the officer and any witnesses can testify about the things that basically are in the report. So Judge sort of covered this, but I'm gonna go through just to make sure we're all on the same page. The question is, would you rather be robbed here in this dark alley or here at a Spurs game? Juror number 13. Now, I know you don't want to be robbed anywhere, but if you had to be robbed, where would you rather be robbed? Spurs game, right? Why? Yeah, Yeah, there's people there, there's lots of witnesses. Can anyone else give me a reason why they would prefer to be robbed at this first game? 72. Yeah, less likely that some deadly force would be used. Juror number 40.
Some other viewers could possibly intervene.
Yeah, yeah, there's help that could be there. Juror number 19. If for the
It's, if you're in the dark alley, so
Yeah.
it's your word versus theirs.
exactly, yeah. So in the dark alley, it's one person there. You. Juror number 9.
Also, at his first game, he can get help.
You can get help at a Spurs game. There may be cameras at a Spurs game. There may be additional physical evidence that we discussed. But I guess while we're talking about, let's say someone is robbed at the Spurs game and you're called for a case. Would anyone expect to hear from everyone in attendance at that Spurs game in order to be like that officer? Now, the law says that even in that other scenario, that dark alley, that could be enough in order to prove a case. So the example that I give is like, let's say we got out of here late. We won't get out of here late, but let's say that we did. You're walking in a dark alley, someone comes out and robs you. Juror number 17, you walk out, you see juror number 18, she comes up to you, she pulls out a knife to give you a watch. Now let's say you go to the police department, you say, hey, I was just robbed. I know it was juror number 18. I know because I sat next to her for the last hour. It was her, I'm sure of it. And the officer's like, well, were there any cameras there? You're like, no. Okay, were there any other jurors there? No, it's just me. And then the officer says, well, I'm sorry, that's not enough. I need more than that. Does anyone think that that's fair? No, right? And so that's why the law says that if we bring one witness, and if you're a juror and you believe that witness proves all of the elements to you beyond a reasonable doubt. So all those elements that I went over on or about a certain date code of law, and you find that witness credible, that that's enough. So does anyone have a problem following the one witness rule? Is everyone saying that they can and will follow the one witness rule if they're chosen as a juror on this case? Yeah. So like, we can't go over the facts, but I do have to go over some possible defenses that I think could potentially come up. One of them is self-defense. That comes up a lot in many aggravated cases, assault, robberies, and things like that. This is a legal definition. A person is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful force. The way that I like to explain it is consider it like a chair. The seat of that chair is self-defense, but before you can get to self-defense, you have to have the 4 legs. It has to be reasonable, has to be immediate, has to be necessary, and it has to be against someone unlawful support. So I can't try to take juror number 29 water bottle and then he takes it back and I punch him and say self-defense. Does that make sense? Because I'm using it's unlawful. Does that make sense, everyone? Another thing that we have that I will cover is voluntary intoxication is not a defense. One more question. So the goal of the justice system is, and raise your card if this applies to you, how you feel, is to punish people when they do wrong and deter others from doing the same thing, or rehabilitate a person who does wrong and get them help. Does that question make sense to everyone? Yes. Okay, so who feels that one is how you feel? The goal of the criminal justice system is to punish someone who does something wrong. 3
Is or should be.
should be. 3, 8, 11, 12, 13, 14, 17, 19, 22, 23, 25, 26, 27, 29, 30, 32, 35, 37, 38, 43, 44, 45, 49, 50, 54, 59, 57, 58, 61, 62, 63, 65, 66, 69, 70, 72, 74, 75. I assume that everyone else is too. Is there anyone who wasn't gonna answer? Like, I can't decide. Okay. So 27, 28, 31, 41, 50, 51, 53, 55, 56, and 73. As the judge said, and 55. You have a question?
Well, it's not what I can decide, it's that I don't think it's a binary choice. It's okay if you vote.
And so do you feel equally for both?
I'll agree with that.
Okay.
That's kind of how I feel too.
Yeah.
I just feel like I answered one.
Yes, and yes, I would like to tie everyone down to one answer, just to get how you feel, even if it's only slightly 51%. But I understand that some people are like 50-50 can't decide. As Jeff said, it's a two-phase trial. He's elected to go to the jury, so if you're chosen on the jury for punishment, first phase is what we call guilt innocence. The only thing that we can discuss are the facts of the case. We can't talk about any other factors outside of that. The second phase is the punishment phase. That's when all the other things come into consideration. That's when you learn other background information to help you make a decision on what you think the appropriate punishment should be. Just that defendant can choose to go to the judge's jury for punishment. He chose to go to the jury to yell for punishment. And so that's something we look forward to if we get to that point. If you're chosen on the jury, you must be able to consider the full range of punishment. Aggravated robbery, it's a first-degree felony, so the range is anywhere from 5 years to 99 years in the Texas Department of Criminal Justice. Is there anyone here who is unable, and knowing nothing about the facts of the case, all you know is that it's an aggravated robbery case? Is there anyone here who is unable to consider that full range of punishment? And it's a wide range, it's 5 to 99. There's anyone who is unable. So we have so 8, 6, 21, 32, 35, 39, 60, 71, 73. And so I guess the question is, for those of you who raise your cards, knowing nothing about the facts of the case, just knowing that that's the range of punishment, I guess knowing that that is the range of punishment, will that prevent you from making a decision on guilt innocence? So let's say we proved our case to you, we proved it beyond a reasonable doubt, but then knowing that he's chosen to come to you for punishment, and so you're going to have to make a decision within that range. Is there anyone who says, first, I would not be able to make a decision regarding guilt innocence, or I would hold the state to a higher burden because that is a range? 35 and 39 and 8. And so 8, 35, and 39, I'm gonna follow with you.
27 seconds.
Ooh. Not gonna follow up with you. Is there anything that I didn't talk about that you think that we need to know as to why you would be unable to be fair and impartial? So I covered a lot of topics, but I didn't cover everything. So here's your chance to say, hey, you didn't talk about this, but I think it's important that you know. You're number 39.
Very specific to me, I guess, but I judge to this. My sister-in-law went through this exact thing a couple of months ago, and the police screwed up so bad, the victim was the one who got arrested. And then since it was all messed up, we can't press charges against the guy who did it, so I couldn't be impartial in this case.
Okay, thank you. 59?
So this is tough. It would be hard for me to be impartial because I'm big on mannerisms, and this has been my way all the time, but I have been looking at him.
All right, so we're going to stop you right there. State, your time has expired.
Okay.
Thank you. Thank you. Defense?
Thank you, Your Honor. Ladies and gentlemen, I want to thank you for being here. I know everybody has a busy schedule and a lot of people are very, y'all have been here a long time. And I want to thank you for your service, for coming and being part of this whole procedure. This is what makes this country great, as they say. You heard from the state of Texas, basically the textbook definitions of a lot of the law. But as in any case, there's a lot of situations where there's a lot of gray areas. It's not all black or white. So I'm going to ask a few questions. They may be general, some of them may be specific. So please understand, I'm not trying to pry into your lives. I don't need to know everything, but there's some things I do need to ask about. You can answer if you wish. You don't have to answer if you don't like to. As Mr. Sanders said, not every case, everybody could be a good juror. He gave you an example if somebody had robbed you, or in this case, somebody broke into his car. Well, he didn't like burglars. He didn't like people like that. So he would have a bias. And that's what we're talking about. How do you feel about these things? Is there a bias already in you're looking at what's coming up? Okay. You're coming in here to basically judge a person, to judge whether his actions were criminal or not. Okay? And it's not an easy thing. It's hard to be sitting and judging of somebody. Okay. So what I need to do is understand the first thing is there anybody here that, as Mr. Munoz sits here, cannot stand up and tell me that they believe in their heart that he's innocent? Right this very second. Anybody here? Number 7, you don't believe he's innocent. Now, with my experience, I would say he wouldn't be here if somebody had. Anybody else feel that? Yes, sir, number 35.
Really the same thing.
All right, let me pause right there. So everyone is presumed to be innocent unless and until the state has proved their case beyond a reasonable doubt. Does everyone understand that? All right, defense, you can continue.
But even that being said, is there anybody here that has a bias against that idea? Anybody here that doesn't believe that? Anybody here that questions that? Yes, besides you, sir. Yes, sir, and number 35.
I just want to explain my deal. I've got 3 kids, and all 3 of them got felonies. And I don't know what his deal is yet. But from a parent, he's got a dad and a mom. So why I can't make those decisions is because of what's happening in my life. So that's why I'm saying.
I appreciate it, sir. Yes, number 56.
I have a little bias as well because of my mother, my brother, and as well as myself has been robbed by gunpoint, as well as working in different industries.
I appreciate it. Anybody else who wants to share? Anybody else? Yes, ma'am.
I believe I'm impartial for this because I have been robbed my house, got broken into by gunpoint. Since then, I have concealed carry. I have license, I am trained. If somebody broke into my house, I could not wait to prove them innocent or guilty. If they're in my house breaking into my stuff at gunpoint, I'm done.
And so do you think you could be a fair and impartial juror?
Yes.
If somebody accused
I
you?
don't think I could be impartial for this.
Anybody else? Yes, Ms. Green.
Yes, someone broke into my house and I was there, so and he robbed me.
Can
It
you,
was a gun.
can you, hold on. Mr. Hernandez, you're walking here. I can't hear. Repeat it.
Yeah, so someone broke into my apartment and I was there. It wasn't at gunpoint, but they did rob and they threatened. And so I do have a bias against that.
Thank you, ma'am. Appreciate it. Anybody else? Anybody have any family members other than, or your immediate family, like cousins or even friends that this has happened to that might affect you? That you could not be fair and impartial. Yes, sir.
I don't know if it would be that I couldn't be fair, but I was, I guess it would have been considered aggravated robbed as a child as well. So I'm not saying I couldn't be fair, but it did happen to me since you posed the question that way.
I appreciate it. Thanks. Yes, number three.
I had a friend of mine, took my checkbooks years ago. And for $10. They wouldn't check his ID. And it. Wow, you know, back, I didn't know about it. Car stereo stolen from me. Good friend of mine, her house got broken into.
Do you think these incidents cause you to basically hesitate when you're being able to be fair and impartial in a case like this?
Unfortunately, yes.
Anybody else? Yes.
When I was 13, I got robbed at knife point. Me and 3 friends of mine were walking home with our instruments. And I was a kid, I didn't know what to do. I was scared, I dropped it, and I ran. As a 32-year-old adult, I'm not sure if I'd do the same, but just give me pause to pause, since I have been robbed at night.
That's very understandable. Like we said, there are no right or wrong answers here, okay? We're just trying to see, trying to fit people that can be fair and impartial, give both sides a fair shake. But not everybody is made for every case, okay? And so there are no right and wrong answers. You just need to know how y'all feel. That's all. Is there anybody here that belongs to any police organizations or neighborhood organizations or anything like that? Neighborhood Watch or anything like that? Number 70? Anybody else? Number 43?
Belongs or have belonged?
Have belonged to or belong to now?
I'm retired military cop.
Okay. Is there anything about that would cause you not to be fair and partial?
I don't think so.
Okay, sir. Thank you. Yes, I'm 48.
Does the security guard count?
Sure, that's fine. They all count. Okay, would anything about that cause you to be fair and partial?
I don't think so.
So Mr. Sanders talked to everybody about the fact that witnesses will come, they will talk, and they will give you their impression of what they saw. Okay. What would be something, and anybody can answer it, what would be something that you would think would cause a problem for somebody testifying from memory? Yes or no, 48?
Trauma.
Trauma, that's a good answer. Yes or no, 25? Okay. So I'm saying a witness came and said, well, I'm asking you, what would cause problem with that witness being able to testify? Number 20. Age. Okay. You're talking about the age of the witness himself? Correct. Number 35. Being biased. Okay. Number 54. Eyesight. Anything else? Number 50.
Maybe like events happen so fast that it's hard for us to keep up.
Okay. Yes, sir. Hearing. Hearing. That's good. Yes. That's my 47.
Time since the event happened.
Time. Talking about how long ago it happened. Is that correct?
Yes.
54. Day. Time of day. And as you saw in Mr. Sanders' pictures, the lighting, did you see the that alley had real dark and stuff like that versus this first game where there's a lot of lights and stuff. Yeah, that must make. But time. Time. Think about that. Time. Three weeks ago on Tuesday, what were you doing?
You know, I'm having a great time.
Yay! Why do you remember that? I was in Disney World having a great time. Okay. How about 2 weeks before that? Do you remember what you were doing?
Yes, I'm a school counselor, so I was busy with star testing.
Okay. All right. Well, that's good. And you know
I don't
why?
remember specifics, but
You know why she understands that, remembers that? Because it was something big in her life. Okay. That's why you remember it. Oh, what if we're talking about 2, 3 years, 4 years? Does anybody think the time will have an effect on anybody's memory? So obviously, if we had something that happened yesterday, and we could get everybody together and come in and have a trial the next day, right? Everybody agree with that? That would be the best thing. But if it didn't happen that way, there's a possibility. Yes, number 56.
Well, if it's dramatic, I think they will remember most of it.
Oh, I guess, I
Especially the
agree.
details,
I
like
agree.
that.
I agree. I think you're right. That's what this lady right here was saying this year. That's why she remembers where she was. Something was, a big event. Okay? But still, as long as time goes by, memories tend to fade. Does anybody have anything contrary to me to believing that? Is that true? Yes, sir.
I think that it's when you have like a significant event, you can remember like some details of things that happen. Then you want to see.
Okay, that's fine. Yes, ma'am. I'm 16.
I agree with the man, if it was traumatic, then you'll never forget things like details.
Okay. Now, Mr. Sanders showed you a bunch of items. Gun, sword, knife, there was something else. Baseball bat. See, everybody remember that? Huh? What happens, or what would you think if, or would you require the state to produce any alleged weapon?
I'm gonna get to a proper question.
All right, that'll be overruled.
Anybody have a problem with that? They can't produce it? Yes, sir.
So in that question, if there's a witness that says that it was there, then no, I wouldn't have a problem.
So if a witness says it was there, that's good enough for you.
If we're talking about credible witnesses, then yes.
Anybody else? So we talked about time. We talked about other questions. Let's talk about punishment. If you were to find him guilty, a lot of people said here they didn't have a problem giving him the maximum, if that were the case. Is there just not a whole lot of people who would consider the minimum or probation or something to that nature?
I never heard that said. Hey, we were asked about a range.
Well, you were asked about a range, then the follow-up question was about whether you would consider the maximum or would you consider rehabilitation. The majority said they would consider the maximum. That's the way the question was written, was asked.
No.
You didn't get that? You didn't get it? Okay, so then everybody here could consider some type of probationary period if they needed to.
Yeah.
All right, and so just so everyone, excuse me.
I mean, if there's bodily.
Excuse me, sir,
injury-
just a moment. And just so everyone can know, both, as I said in the very beginning, when the state and defense are speaking to you about cases, it's not about this specific case. So the rules are that you be able to consider the full range of punishment. It's not whether or not you can give someone probation or give someone a specific amount. It's whether or not you can consider the full range of punishment. Does everyone understand?
Yes.
All right, defense.
Thank you.
Your Honor, I have no further questions.
All right, thank you. All right, ladies and gentlemen, what I'm going to do is I'm going to have you all step outside. There's one matter that I need to take up, and then we will bring you back in at 5:25, and we'll let you know who's on the jury. And by bringing you back in at that time, I'm saving you from rush hour traffic. So everyone who's in the box, please make sure you take all of your personal belongings with you. And if everyone leave the white cards in the seats, please. Everyone, please rise. Yes. Leave us, please. All right, we're gonna have Christine Del Prado do the plea, and then we'll have Christine take up your matter, Mr. Valentine.
Thank you.
Yes, they're conferring. All right, thanks.
Tomorrow?
9:30.
See you tomorrow.
All right, thank you. Oh, did y'all already agree?
Yes, sir.
All right, let's see what y'all agreed on. All right, what numbers?
6,
Just 1 second. But before you start with that, number 1 was agreed to be excused.
Yes.
Number 4, agreed excused.
Five.
Number 5. And then we have number 34. 42. And 67, is that correct?
Yes.
Yes, Judge.
All right, so which numbers are you agreeing on?
6,
Okay,
8, 17, 18, 23, 29, 35, 39, 51, 59,
wait just 1 moment. 51,
51, 59,
Mhm.
and 70.
is that correct?
Yes, Your Honor.
Defense? All right, Brendan, that was on the record?
No,
Okay, that's.
I
okay.
can put, I can.
All right,
I
let's
marked
put it on the
them.
record.
Okay.
So we're back on the record. So the agreed strikes are number 1, 4, 5, 6, 8, 17, 18, 23, 29, 34, 35, 39, 42, 51, 59, 67, and 70. Is that correct, States?
Yes. Yes, sir.
Defense?
Yes, Your Honor.
All right, just give me 1 moment. And I always do alternates, so let me see where we are with our strikes. I put us at 45. Is that what everyone else says?
Yes, Your Honor.
All right. 45. All right. And then Mr. Hernandez, you'll get 1 extra strike, and that extra strike must be used between 46 and 49.
Okay.
All right. Thank you. All right. Where is Christine Del Prado? Oh, thank you. Ms. Del Prado, could you take a plea for me, please?
Sure.
All right. And I'll walk you through what they were me to share. All right, court is calling 2022 CR 3544, State of Texas versus Aaron John McDonald. Can I have parties step forward? Where's McDonald? Come forward, please. Come forward. All right, can I have the parties announced for the record for the state?
Christine Del Prado for the state.
For the
Ashley
defense?
Morgan on behalf of Mr. McDonald.
And Mr. McDonald, I'll meet you in the middle. And are you Mr. McDonald?
Yes.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
We have, Judge.
Court will find that the state is in compliance with the discovery. And are you the attorney of record for
I
Mr.
am
McDonald?
not. It's Miss Jody Sawyers, who is on a family emergency.
All right, do you have any objection with this attorney standing in?
No, ma'am.
All right, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do waive the reading, Judge.
All right. State, it appears that you're proceeding on the less included offense of possession of a controlled substance penalty group 1 less than 1 gram. Is that correct?
That's correct, Judge.
Any objections?
There's no objection.
Mr. McDonald, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the less included offense of possession of controlled substance, penalty group 1 less than 1 gram? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Did you understand that the court doesn't have to follow your plea bargain agreement? If for any reason the court does not, you can withdraw your plea, and the fact that you entered a plea will not be used against you. Did you understand?
Yes, ma'am.
Did you understand if the court would grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court will find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. McDonald, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1 less than 1 gram. There's a $500 fine. State recommends deferred adjudication. Will take in consideration County Court Cause number 6762200. There's to be no contact with Daniel, is this Turbag?
Yes, ma'am.
Turbag,
Yes.
or Michael Walentarski, Wolentarski. Do you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense is at the plea bargain agreement.
It's our understanding. Yes.
State is at the plea bargain agreement.
It is, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 3 years. There'll be a TAP evaluation, 100 hours of community service restitution, agreed motion to destroy any seized weapons, and there are no weapons while on community supervision. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations? Then to the lesser included offense, how do you plead guilty, not guilty, or no contest?
No contest.
State any evidence to support the plea?
Judge, I
Yes.
believe they've already given that to you.
There's no objection.
All right, Mr. McDonald, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, and lab reports, but most importantly, there'll be no live testimony. Did you understand? All right, the court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. However, defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
I'd like to call Mr. McDonald. Mr. McDonald, you're currently employed, correct?
Yes.
Has he been sworn, Judge?
He was sworn in by the clerks.
You are, where do you currently work?
EIB contractors. The construction company, EIB contractors,
And what kind of work do you do?
construction.
How often how many hours a week do you work?
Lately not as much due to COVID, but I was 40 hours a week.
And are you asking the judge to follow the plea agreement?
Yes.
Do you have any kids?
No.
Do you support any dependents?
No.
And that's the witness.
Yes.
No questions.
All right. Are you living with someone who has children?
No.
If you're drug tested today, what will the results be?
Most likely negative, but it's been 2 days.
No.
All right, what did you, what did you use?
Sorry. Marijuana.
What else?
And then methamphetamine.
All right, when's the last time you used meth?
2 days ago, Sunday.
How often are you using?
Weekends as well, whatever it was. Yeah.
All right. You shouldn't be operating heavy machinery if you're using, you understand?
Very much so, yes.
All right, how far did you go in school?
2 years of college.
All right, why are you using meth and marijuana? Where did your life get off track?
whenever I was shot, probably. When I was shot in September and died. So 6 months.
So where were you when you were shot?
This last September.
Where
was I?
were you?
The friend's apartment. But yeah.
Yeah, who was the friend? What was happening at the friend's apartment?
Exactly.
You see what I'm saying?
Yeah.
All right, I'm gonna do my best to help you get your life on track, but whether you want it on track or not, that's completely up to you. You understand? All right, we're gonna do 3 years deferred adjudication, $500 fine to be probated, taking consideration county court cause number 676200. There's to be no contact with Daniel Turbay or Michael Walentowski, 100 hours community service restitution. Court will waive 40 of those hours if you provide proof of the COVID vaccination. The court is not requiring you to get that, but if you do, 40 of those hours will be waived. I want a referral to felony drug court. He's going to do the UA hotline until accepted. If he's not accepted in felony drug court, then we're going to do a TAP evaluation and follow all TAP recommendations. There's to be destruction of any weapons. And it goes without saying that you're not allowed to have any weapons while you're on probation. You understand? Proof of employment within 30 days. There's to be no employment as a home health care provider with minors. I'm going to want field visits 3 times per month. Random. Who are you living with?
My parents.
Don't bring nonsense to their doorstep. You understand?
Yeah, I've never done that to theirs. So I don't keep.
Yeah, but you're coming back home high. That's not good either. Okay. So field visits 3 times per month. And there's to be regular reporting by Zoom or in person. Is there anything else that he needs?
No, Your Honor.
Is there anything else you need from the court in order to be successful in this probation?
No, I did want to ask, I was going to be joining a gunsmithing course soon.
Well, let's not do that. Yeah, we don't want to sniff them guns. All right. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, stop using drugs, because you never know what people put in them. They have no concern over whether it's FDA approved or not. They're just trying to make their money. All right. All right, good luck to you.
Does he need to go to probation right now?
Probation is right there. There you go. All right, are you guys done with the strikes or no?
That's it, Judge.
All right. So your case, we're ready. Court is calling 2017 CR 13555, State of Texas versus Michael Fernandez. Could I have parties approach for the record? And if you could announce for the record, please state.
Steve Del Prado for the state of Texas.
Defense.
Patrick Valentine for Michael Fernandez.
All right, the court is in receipt of defense's motion for judicial clemency and the state's response to the defendant's motion for judicial clemency. Since there's a response, I'm making the logical assumption that the state has received your motion and both parties are ready to proceed. Is that correct?
Yes, Your Honor.
All right, defense, it's your motion.
Thank you, Judge. If I could just take up first the state's response. Mr. Prado responded regarding the court's jurisdiction because I believe the system doesn't really accurately reflect when Mr. Fernandez was actually placed on probation. He's in fact still on probation. He has not been terminated. That's part of what we're seeking today. And Your Honor's jurisdiction extends 30 days after the day of that termination to grant judicial clemency. So I don't think that argument applies, but I understand why it was made given the confusion of the system. But addressing the merits of our motion, Your Honor, we are here today seeking judicial clemency from the court. We're asking the court to vacate Mr. Fernandez's conviction for tampering with the government record and allow him to proceed better with his life. Your Honor may remember this case. I think it was probably among the first that he tried after taking the bench. And in that case, Mr. Fernandez was accused of 4 crimes involving official misconduct. The first 3 had allegations of an assaultive nature regarding Mr. Fernandez's treatment of in a particular inmate. He was acquitted on those 3, but the jury did return a verdict of guilty on the remaining count of tampering with the governmental record and that's the misdemeanor version of that offense. For that, they assessed a punishment of 0 days in jail and a $1,000 fine. And Your Honor placed him on probation for a period of 6 months. So then I took the case up on appeal unsuccessfully. It comes back down, and then we had a little confusion trying to get him on probation. Finally did, and so that's why it's taken so long to get back in front of Your Honor at this
No
point.
problem.
But I'd like to present the testimony of Mr. Fernandez, and I think first Mrs. Fernandez, to convey to the court what these last 3 years have been like with the burden of this conviction on his record, and how Your Honor may be in a position to provide this family with a better way forward if you were to grant him judicial clemency. So if I could
Okay,
start with.
and before you start with that, I'm assuming, State, are you objecting to this?
Yes, Judge,
All
we
right.
are. I have a couple of comments with regard to the time frame.
Yes.
And I first want to let you know that in the state's response, I do make a mistake of saying that his probation had ended. It seems confusing on what's going on, but this is in the state, you may have it in your file, Judge, but the original terms and conditions of community supervision were signed by Mr. Fernandez on March the 19th of 2019. So we do allege that his actual community supervision started that date. And when the final mandate came down, when the petition for discretionary review was denied, that was in November the 19th of 2020.
Yes.
And so we believe that by operation of law, his probation then ended 6 months after that, because kind of almost like 5 months after that, because he already started in March of 2019. So even though I know Mr. Valentine had said that there was some confusion of getting him on probation, he signed his conditions of community supervision probation here in this courtroom on the date that he was found guilty of the actual offense of tampering with the governmental record. So it's a little confusing as far as what the dates of when he started and when he stopped would be, but we believe that he is presently off of probation. I know that he shows that he went back in December the 26th of 2021, a year and a month later, after the mandate came down, and that he is still, I think, showing that he's actively on probation, which would mean that it wouldn't be timely filed if he's actively on probation, because you can't grant judicial clemency until it's terminated. But let's assume that he's terminated. So there's a little confusion, and the law isn't very clear about when that jurisdiction ends. Our initial response was thinking that he had already terminated back, and it appeared that he had terminated satisfactory, but that actually was his bond conditions terminated. So it was a little confusing for us to look back at the record. So I want to first clear up the fact that was incorrect when we said that his probation terminated in March of 19. What we do believe, though, is after the mandate came down, after he appealed this jury's ruling to the fourth court, and after the petition for discretionary review was denied, that was November the 19th of 2020, his probation would have, by operation of law, begun again, since he'd already signed his conditions in November of 2020. So that would mean that his probation would have been terminated, or the court's jurisdiction, by approximately, it's another 5 months to that, like April and May of 2021. So that's kind of the first issue that we have.
All right, what the court has in the court's file is that conditions were signed on December 13th, 2021. Is that what everyone has? Because that's what I have in the court file.
That is what I have.
Well, Judge,
I know he initially signed one right after the trial, but then when we
Yes.
took appeal, that was stayed.
Yes. So once they went up on appeal,
yes,
then what ended up happening is he wasn't placed. Technically, he wasn't on probation. He was appealing. And so I didn't enter my orders until I think in December, and he was actually placed on probation, and he actually signed his conditions on December 16, 2021. And it came back to me to sign on December 7th, 2021. So that's when I signed his conditions of probation. Is that not what everyone has?
That's when we believe his probation commenced,
All right.
because that's when he was active supervisor.
All right, so here's my question. This is where I'm at, because I want any testimony that I hear to go to the issue that I'm looking at. So I've read the state's response, and I've read your motion in great detail. And my question is going to be, how is the person who's standing before me, Mr. Fernandez, any different than anybody else who has a tampering with a government record? And they're on deferred for it, or regular probation. He's on regular probation, but they're on probation for it. How's he any different from anybody else who's never had any criminal history? Because there are some people who have been placed on deferred adjudication or regular probation for tampering with evidence, and they never had any criminal history before they had a tampering with evidence. So my question would be, how's he any different from those people who have that as well?
And we intend to demonstrate that, but I would also say I don't believe that judicial clemency is a procedure that's utilized enough in Texas. It's something that gives your honor discretion to actually make a difference in people's lives and give them back some portion of their future. I know this administration purports to be all about justice reform and all that, but I see too few lawyers and too few judges, frankly, considering judicial clemency as a possibility at the end of regular probation. But that said, I would like to present testimony that I hope will convey to the court how these are very good people and they were seeking to live a better life. And this conviction is an encumbrance on that. And by removing that encumbrance, Your Honor, you not only vastly improve the conditions of the future for this family, but also make society just a little better by allowing Mr. Fernandez to resume a role as a fully contributing member.
And I think, State, are you going to not stipulate that these are good people?
Yeah, and you're absolutely right, Judge, and I don't disagree with anything Mr. Valentine has just said, that I'm sure Mr. Fernandez is a good man. The concern I have is that as the state, this was a jury of 12 people in your court, as you'll recall. And
Yeah, it was,
sorry.
yes,
It was 6.
yes,
I apologize.
with 2 alternates.
Yes.
Because I always do an alternate.
It's true.
All right, then
And,
we'll,
and so I will agree with all of what he said about that, I'm sure he's a good man. I don't see where there's any difference between anybody else who has remorse over the fact that they were convicted. And again, when the state had given the opportunity for deferred that was not accepted, he could have already had a non-disclosure on this, which would have put him in a very different position than he's in today.
Well,
These are choices that were made that I appreciate. In hindsight, you wish you hadn't have made.
well, I will tell you, the court will disregard any plea negotiations that may or may have happened, because the court is not aware of those,
and I understand that, Judge.
and the
but
court
when
will
somebody's
continue to be
asking-
unaware.
But when somebody writes letters asking for clemency, saying that their choices that they made by following their attorney's advice that they wish they hadn't have made, to me, that brings that issue up.
I don't believe that's their position. I mean, let's remember, he was acquitted on 3 of the 4 charges here. I mean, he had very good reason to go to trial on these cases. He couldn't parse them and choose them out. And as Mr. Fernandez will testify, no offer was ever conveyed to him. And I don't think it was ever conveyed by the state.
Well, this is what I will say. I will say that in 187 District Court, I make sure that the state makes an offer in every case, because those are the rules in my court. You can make whatever offer you want to make, but I require that the state make an offer, and then the defendant, whoever it may be, can accept or reject that offer. So there is no, people didn't get an offer. Now, I don't know what the state is offering. The state may have a case where they're like, we want the death penalty, or we want life. Even if that is their offer, I still say you need to make it to the defense. So I don't let anyone walk away from this court not having been tendered an offer.
And if I and I believe I did say an offer was not conveyed by the state. I retract that. I have no idea. All I'm
Okay.
saying is Mr. Fernandez does not remember an offer being discussed with him. And again, frankly, he beat 3 of the 4 charges. He had very good reason to go to trial. This isn't a buyer's remorse situation.
Yeah.
Well, if I could just speak to that briefly.
Okay, just 1 second. Defense, off the record for a moment. Mr. Hernandez,
Yes, Your Honor.
have you finished with your selections?
Yes, Your Honor.
All right, are we ready? Have you,
I didn't see that many.
all right, have you turned them in, Mr. Hernandez?
Not yet, Your Honor. I was just thinking that.
All right, so let me ask you all, because I don't want to keep Brendan here too long. We are, we're starting jury trial tomorrow at 9:30. How long do you expect your 2 witnesses to be?
5 minutes apiece.
All right, are you able to be here tomorrow? I'll need you all here at 9 though, because I want to start the jury immediate at 9:30. Are you all able to do that? All right, if you're not, let me know. We'll put it on a different day.
We want to get this done, so I think we can do that. We appreciate
All
it.
right, just make sure you're here at 9. Otherwise, if you're not here at 9, I'll still get to it, but it'll be during a break. Okay, thank you so much for coming. Thank you.
Thank you, Judge.
Thanks, Judge. When you slowed down, I saw her face relax. Poor thing. She gets on autopilot. Right?
Thank you for your time today.
Oh, excuse me, Miss Del Prado. I don't. Oh, no, I can have the prosecutors here do it. It's
you
a
need some?
bond. No, I always have the state see if they can confer with the defense on bond
Is there
issues.
somebody here to do this with?
No, he just filed it. So, and of course, he's entitled, yes, and of course, he's entitled to it, but they're in jury trial, so I don't know if you'll agree to him out.
Judge, you've had that rule for a long time.
Yes.
I remember
Since the very beginning.
you did it from the very, yeah, you're right. This was one of the early. I don't think you make it put on the record.
No, that only goes on the record if defense counsel wants them to put it on the record.
That's right.
But you know what, my students, I always tell them, you should always, instead of having a court reporter do it, because you never know, court reporter may win the lottery. So, yeah, I always tell them, just type up something, get it in writing and have them sign it. All right, so we're gonna go on the record. State defense. These will be the persons on the jury. Please let me know if it is correct. Number 2, I'm sorry, Markson, Velasquez, Martinez, Hernandez, Hilton, Guardiola, Sanderlin, Flanagan, Malloy, Noriega. How do you pronounce with the double L's? Santignon, Grand, and the alternates are McAngus and Thomas. Any objections, state?
No.
Any objections, defense?
No.
All right, let's bring the jurors in. This is the back of mine, so we just leave it here. And then I'll leave Mr. Munoz up here as well.
He just wants to look it over a little bit. He said it.
All right, thank you. At least they miss rush hour traffic. And everyone, you will see sheets of paper. Please only take one so that other people will have one. Yes, thank you.
Yes.
Those last two, please, because I was timing it, because it should have been, you should have been out here by 5:30 at the latest. So the last, please.
Everybody else, come on in.
All right, everyone, please be seated. All right, so everyone, please make sure you have one of those square sheets of paper. If you don't have one, just raise your hand and we'll make sure that you get one of those sheets of paper. I want to thank you all for your service, for being in what court? What floor? All right, and who's the judge? All right, so here's the thing. I can, for those of you who are not going to be on this jury, I can have you all come back tomorrow to be considered again. All right, let that marinate. Don't be too anxious, because by us leaving at this hour, I saved you from rush hour traffic. So just hold on to that in your pocket. You all will receive something where you can get payment for your service, or either you can donate that. There are many organizations that you can donate that to. Otherwise, what will end up happening probably 2 or 3 months from now, you're going to receive a check in the mail and you're going to be wondering, what is this for? This is fantastic. Then you're going to remember the fantastic time you had in the 187th, and you'll be able to go buy lunch or walk on the Riverwalk with that. So the 187th is open. You're always welcome to come back. I'm going to call the persons who will be on the jury panel. When I call your name, please take a seat in the jury box. Gail Markson. I say Velasquez. Jennifer Martinez. Karina Hernandez. Amanda Hilton or Highton. Thank you. Alfred Guardiola. Andrew Sanderlin. Arthur Flanagan. Karina Malott. Ricardo Noriega. Melissa Santillon. Galen Grand. Megan McAngus. Jefferson Thomas. All right, everyone else, thank you for your service. I know that you go downstairs usually to have your parking validated. But when you leave, just let them know you are here and they'll make sure to give you the discounted price. So everyone, thank you so much for your service and don't be a stranger downtown. All right, everyone, please rise. Oh, no, you all remain seated. We rise for you. I'm going to give you all some instructions and then I will release you for the day. Okay, everyone, please be seated. All right, so everyone, these are your instructions. We're going to start tomorrow at 9:30. So make sure you come a little bit earlier because you'll have a better chance of getting parking space. When you report, you will not report to this courtroom. You'll report to the jury room and Deputy Laura will show you where that jury room is located. I have absolutely no control to the temperatures in the courtroom. Sometimes it's super hot and then sometimes it's very hot. So we fluctuate from super hot to very hot. There's a thermostat over there. That thermostat actually does nothing. It's a placebo thermostat. It's just to make you feel good when you switch it. You can bring drinks, but make sure there's a cap on it or something so it doesn't spill if it gets knocked over. I don't expect any publicity to be involved in this case, but you're going to be given juror badges. Make sure you wear those at all times, especially when you go on your breaks or when you come to the courthouse. Deputy Laura will again show you where those are as well, because that way people won't be talking around you about different cases, which sometimes attorneys are known to do that. And I don't want you to hear anything that you shouldn't hear. Do not try to investigate, do not research, do not look up anybody's name. Everything that you need to make a decision on this case is going to come from inside the courtroom. Does everyone understand? Yes. So there's to be no investigation, no doing research or looking at any type of media. If you see something that you think is about this case that comes up, just turn the channel or don't read the newspaper. But again, I don't expect that to happen. Does everyone understand? All right. So here's the other thing. I'm going to make us start exactly at 9:30. And when I say make us start at exactly 9:30, I do have other cases that come into the courtroom tomorrow, but I'm cutting them off at 9:20 so that I can get you all in here at 9:30. But we cannot start at 9:30 unless everyone is here at 9:30. Does everyone understand? All right. So when you come back tomorrow, Deputy Laura is going to show you where you need to report, and then I'll swear you in tomorrow. Okay? Any questions? Yes.
Are you gonna get something that says we were chosen for the jury?
Yes.
The email or like a paper?
It will be paper. Yes. Anything?
What time would it end?
Well, this is not California. Oh, okay. Let me explain that. Here, let me just tell you, this time here is very unusual to have a jury here. It just ran over because we had other cases that were scheduled, but I had other things on the docket. So whenever I have a jury selected, I make sure that the docket is clear on Wednesday so we can start soon. I normally will have you out of here by 4:30 so that you can avoid the rush hour traffic. Now, the only exception to that is if there's a witness, maybe on the witness stand, and we're in the middle of them testifying, usually we will go beyond that. But otherwise, you're out by 4:30 so you can avoid the traffic. Anything else? Yes.
This is for sure not going to interfere with my travel next week that I can't change.
I don't think it will. Yes.
If we want to take the bus and we don't, can we still use the jury summons even though it's a day old? Because they close school.
You mean as far as using, if you take the bus, getting a bus pass?
Right.
We'll work on that. Okay. Yes.
Will this still be going on Thursday this week? I have a doctor's appointment at 3:15.
Okay.
So if I need to reschedule, I'll try it.
All right, we will see where we are, okay? All right, and one final thing before I let you go. People will be testifying, of course. If there's anything that you can't hear, let us know. It's hard for me to see because I have this screen, but just raise your hand. And if you raise your hand, either the defense attorneys, I'm sorry, the defense attorney or the state's attorneys, or Brennan, who has eyes in her back of her head, will let me know that you need something. And if you need a break, let us know, okay? Yes.
It's probably a dumb question, but does it matter if I know one of the bailiffs? And are these bailiffs gonna be the ones in the same?
I don't anticipate either one of them testifying.
Okay.
All right. No, and there's no such thing as a dumb question. I tell my students that all the time. Well, there is a dumb question. That's the dumb question is the unasked question. That's what I always tell my students. So just ask it.
Okay.
All right. Is there anything else? All right, then I will see you all tomorrow, and Deputy Laura will have you lined up outside the door by 2:29, and we'll bring you in. All right, everyone, please rise. I'm sorry. I said 2:29. Sorry, it's long. 9:29. 9:29.